May it please your lordship. May I pray for listing of a matter for motion? I would have prayed this afternoon, but tomorrow, otherwise it may be finalized.
Okay.
Tomorrow.
Same period, my lord, for motion on my lord, tomorrow, my lord.
Why?
My lord, because it is a matter of settlement, my lord. We filed.
Made please your lordship. I beg to mention item number 30, my lord. 30. Well, this matter has become infectious, my lord. The order has already been completed.
But P,
Yes, my lord. 30.
why it is infectious?
My lord, there are other connected matter, my lord. So in all the cases, my lord, the petitioner is awarded with the work, my lord.
Awarded with the work.
Yes,
So there is some order.
my lord. Just
The
close
order
the.
has been complied with,
Yes, my lord. Yes, complete.
order dated.
My lord, the work has already been completed by the petitioner, my lord.
No. See, it's a contempt.
Yes, my lord.
How do I close a contempt? It
Well,
has to be complied with.
Well, there are
To
some
drop
other
the
contempt
contempt.
cases also are there. Total 5 packages were there, my lord. So, my lord, all the works were awarded, my lord.
No, what was the order passed by this court?
My lord,
When the matter reaches.
to award the work, my lord.
Huh?
To award the work to the petitioner.
There was a direction to award the work
To the
to
petitioner,
you.
my lord. Yes, my lord.
Okay, we'll have it when the matter reaches.
My lord.
It is a lordship in respect of item number 3. I have filed an affidavit of opposition. May it be kindly called for. Right.
My lord, in item number 28 also similar prayer. I filed affidavit in opposition on Saturday.
May it please your lordship. Lordship, with respect to item number 26, lordship. With respect to item number 26, lordship, the respondents have filed the affidavit, lordship. As per the last order dated 25/7/2025. Lordship, I seek 1 week's time to file a reply, lordship.
Earlier you took time?
No, lordship. Lordship, as per the last order 25/7, lordship, they filed a affidavit. The first affidavit.
The first we have.
30.
I don't give accommodation for filing affidavit.
Lordship, reply, lordship, we're going to file a
You have to take it like this.
lordship.
The counsel appearing on behalf of the petitioner seeks for an accommodation, list the matter of the 6 weeks.
Lordship, there is an interim order, lordship.
Interim order stands vacated.
Lordship, then lordship may take up the matter during the course of the trial.
Yes, don't have question.
Apologies. My lord, item number 10, my lord, in fact, it's a civil bench one matter. Now, only confusion is that it has been shown a part hard, but lordship only kindly see 16/6/2025. The matter about the fixation of court fee act, my lord. Lordship only indicated that the matter would be further hard. My lord, lordship, we want to take.
What is the matter about?
My lord, here is my lord that the learned additional district and session judge dismissed the appeal on the ground that so far the court fee act is concerned 74C. The quantum which has been decided there 20 lakhs about that, my lord, declarative suit, and my lord 200 rupees for my lord permanent. That
What do I do?
it's a civil one matter. If lordship wants to take, I don't have any objection. Otherwise, my lord, it's not a
Hello.
part hard.
We'll see when the matter
Well.
is.
May I please your lordship? I beg to mention for item number 29, lordship, fact sanction order, speaking order already passed. Lordship, petitioner has no objection to close the matter, lordship.
No,
Order,
they have complied with it.
Miss R.B. Bora, appearing on behalf of the respondent, submits that in compliance to the order dated 3/1/2022 passed in WPC number 7/333/2021. The speaking order have been duly passed. Whereby the claim of the petitioner have been rejected. Taking into account the same, the said order, passing of the, taking into account the same, the order passed by this court dated 3/1/2022 in WPC number 7/333/2021 having been complied with. Nothing further remains in the instant proceedings for which the contempt proceeding stands dropped. Be that as it may, this court, however, observes that the dropping of the instant contempt proceedings shall not prejudice the petitioner to challenge the order dated 24/10/2024, if so advised.
deeply.
The said order dated 24/10/2024 as placed during the course of the hearing is kept on record and marked with the letter X.
May I please, Lordship? Lordship, I beg to mention for withdrawal of a case, Lordship. And this matter will fix on sixth, Lordship. For withdrawal, Lordship,
When?
on sixth. Right.
For motion item 1.
Why there are two contempt cases?
Lordship. It is this, Lordship, notice.
এই বেলেগ বেলেগ দিছে তখন দুটা। এই, বেলেগ হয়। Item 2. Yes, what is this?
Lordship, if Lordship come to page 13, the order which was violated by the private respondent number 5.
Where is that order? Yes.
Lordship. Lordship, page 13. The petitioner agreed by the
What is
Indian
the
order.
direction? In the interim, this court finds that the prima facie case has been made out for staying the impugned order dated demand passed by the Iman in as much as running of the market private is within the competence of the state government, which have been decided by the principal. Accordingly, the order dated here state state. Yes.
Yeah, my lord, this order 35/2025, this was passed by the District Development Commissioner against and contrary to the speaking order passed by the Deputy Commissioner, District Commissioner, as well as the Secretary PNRD Department. This order was passed. My lord, we have approached this honorable court challenging the order dated 35/2025. And after hearing the party, my lord, this order has been passed. Order was passed. Yeah, my lord, the contemptor already lost an caveat before moving the application. Already we served copy, and after hearing the contemptor also, this order was passed. This order was passed on 18/6/2025, and again on if my lord come to page 19, these are money receipt.
Page?
Page 19. This
20?
type copy.
Page 20.
And
Page?
page 20 is money receipt, Lordship.
20.
Page 20, Lordship. 19 is a type copy. Page 20, Lordship. On 26/2025, they, after passing the order of this honorable court, they also reopened the market, Lordship, private market.
So they open only on 26.
26.
Thereafter, what happens?
Thereafter, I do not have access to.
Find out thereafter.
Lordship,
Why should they issue notice unnecessarily? They may not have known because the order was passed on 18/6.
Lordship, after hearing the contemptor also,
Find out any other thing have been done in recent past. Why have you moved this court today? There must be some personal enmity between both of you. Is it? Some
Lordship,
personal
we
enmity.
have done market.
Is it presently running? It is, these markets are run under the aegis of which department?
Panchayat and Royal.
Panchayat, any council? No council. Hello, find out.
Lordship,
Find out is there anything, because this is only immediately thereafter. They may not, the council may not have informed them. So may have, find out anything of
Lordship,
recent past. Give you 1 week's time to file an additional.
Lordship, they have also filed caveat before.
So
caveat-
what? The council may not have informed them. Find out any other date thereafter.
Lordship, then,
Because all these are dated 26/2025.
Lordship,
Why? Find out in recent past. You have moving this in the month of August.
Lordship,
Have they done anything in the month of July?
Lordship, we have
June.
filed-
June? June last week.
June last, Lordship.
All these are 26. I've looked into it. That is why I'm saying. Isn't it?
Lordship,
Then
Lordship, connected matter, Lordship, rate petition three.
forget about connected matters.
Lordship,
The counsel appearing on behalf of the petitioner directed to bring on record by way of an additional affidavit as to whether after 2025 is there any violation to the order dated 18/6/2025 passed in WPC number 3389/2025. List this matter again. How much time you require?
2 weeks, Lordship.
2 weeks. List this matter on 18th of August 2025.
I love this.
Item 2.
Yes, what is the order?
My lord, direction is at page 10.
Action to pay.
Yes, my lord. 11, it is a direction to pay.
Who is the department?
Police department. Assam Police.
How are you filing this contempt?
My lord, he filed the.
Order was passed in 2022. We are in 2025. How?
That is, my lord, the petitioner is.
Isn't the limitation 1 year?
Yes, my lord.
Then,
My lord, petitioner is 80 years old. Recently,
so
his wife also expired, and out of my lord, treatment, etc., my lord, he has, I have explained that phase 8. My lord.
yes, government, you are there. You appear for the this police department. Yes, we have it next week. Obtain instructions as to whether the order has been complied with or not, my lord. And give a copy to
Today I am.
because the instant contempt proceedings have been initiated alleging willful and deliberate violation to the order dated 7/11/2022 passed in WPC number 2200/2022, whereby there was a direction passed by this court to make verification and thereupon to make verification and if found entitled to pay the petitioner within a period of 4 months. It is seen that pursuant thereto, the petitioner had submitted the certified copy of the order dated 7/11/2022 on 21/11/2020 on 12/12/2022. However, the same have not yet been complied with, for which the petitioner has approached this court. Mr. G. Bokolia, the learned counsel, who represents the Director General of Police, shall obtain instructions as to whether the order dated 7/11/2022 have been passed in WPC number 2200/2022 have been complied with. List this matter again on 13th of August 2025, on which date Mr. G. Bokel shall obtain the necessary instructions. A copy of the contempt petition be served upon Mr. G. Bokel during the course of the day.
May I please, Your Lordship, on 12th, my lord, 13 I will be out of station. 12th on. 13 I will be out of station, my lord.
Huh?
13th August I will be out of station, my lord. 12th.
On 11th.
My
name may be reflected in the post this one.
And the name of Mr. G. Bokel be reflected in the cause list.
Item 3.
You just obtain that instruction. If it is, I issue notice. Otherwise, I don't issue notice.
May it please, Your Lordship.
Yes.
There was a clear misunderstanding between a co-owner and a co-partner, my lord. Now, apparently, my lord, the lease deed is in respect of 1 acre of land. And the wife of the third brother, though patta is same, but they are owner of a separate plot of land. Now they have confused me, Lord. Lordship, should
It-
kindly,
It is not a separate plot of land, it is the same plot of land. This separation happened later on.
no, yes, yes, that's a fact. If your Lordship should kindly come to this document, my Lord.
Did you submit in terms with page 136, the notarized affidavit?
Yes. No, I just wanted to draw your Lordship's, yes, 136, yes. Page 45, my Lord, in terms of 146. 140, page 45. That my deceased husband Kanuram Putradhar, along with Bokanto Putradhar and Barindor Putradhar, both son of late so are co-partners at page 45. This was the affidavit. Are co-partners of total plot of land measuring 2 bigha 13 lessa, covered by DAG number 90, patta number 13, in revenue village so and so, so and so, so and so. That I have been possessing and enjoying a part of the plot of land measuring 3 kota 11 lessas as my share as per mutual family partition out of the total plot of land measuring 2
Mr.
bigha 13.
Chaudhary, that is not in terms with page 136. Annexure 3.
Not in, but no, in form it may not be, but in substance it is the same, my lord.
No, does it mention that I understand the definition of family? Because at that point of time,
Hmm.
in fact, you should have submitted the partition document.
Prior to that.
Prior to that, you did not. You waited. You
No.
got the partition, although everything was done, but that was that
No, it
partition.
is a fact, my lord, that the separate, the partition was done after that.
Hmm.
But my lord, before the decision, but before the decision.
Yes, but did you place that document?
Yes, yes.
Which one?
Page number, my lord, 50. Page 50, my lord.
This was placed?
Yes,
And I've given a page 9, para 6 on 1st June.
para 6, my lord, we have made that statement.
And they are not denying also.
My lord, this is placed on 19/4/2025. The cutoff date is the date of application. Before the date of application, the notary affidavit of one co-owner is given on 26/9/2023. As per the next of kin certificate, there are 4 more major co-owners who have attained majority. If they had given one, they ought to have given all the rest. Secondly, my lord, the clause is pretty clear that it cannot be, the consent or an NOC is not sufficient. They have to execute the lease deed. In this regard, my lord, I placed certain decisions. This is clear on that, my lord. Exactly on that point. Squarely covers. There's a division bench of this honorable court as well, and Allahabad High Court as well as Madras High Court.
Is Allahabad to আমার ATP
আমার কি কয়?
co-partner is co-owner.
পাঠিয়ে করতে। দু প্যারাগ্রাফ। না, খালি কেমন দেখা খালি এটা
Division bench did not deal with that.
Yes.
It was withdrawn.
Well, this was withdrawn, and there's another judgment before on those point as well. Clause 4.6a. The other remaining judgments deal specifically with clause 4.6a.
Our High Court judgment, it was a case of a co-owner. It's not a case of a co-owner, it's a case of co-partner.
It was a case of co-owner.
Owner.
Now, your case is also a co-owner. It is not a co-pattadar. Because you see, it is not a pattadar
So there is the
business.
same patta.
No, it belonged to your predecessor.
Yes, sir.
Well, yes.
Sir.
Snell is my predecessor, my father-in-law, my father, in fact.
But your father, wherein your father the father was the owner. Thereafter, it devolved upon his two sons.
Three sons,
Like,
one died.
three sons, of which one son must have predeceased.
Yes.
And as such,
My-
it has gone to the widow,
Wife and the children.
children. So wife and the children. So it is a case of co-owner, not a co-pattadar.
No, if your lordship would kindly come to our High Court's order, my lord, the earlier order which my learned friend has placed
Which one?
at page, read appeal order, my lord.
Read appeal is a different thing.
Yes.
It is a case of withdrawal. I'm not on that.
It is not. Page 36.
In its order also consider the fact that the patta is the owner, immediately the land covered property is having a joint and the lease deed has been executed by only one owner. So they absence of
Offered plot, third plot.
the water could
So it is not
council
like-
replace the criteria.
And type of, type of.
I don't know what. Recreated from the.
Some deliberation automatic. Withdrawn this, there is no value.
Ashish Verma
If
also.
lordship would kindly come to page 36 of the writ petition, my lord, the layout of the sketch of offered land, my lord.
Hmm. Yes.
Page 36, kindly see the square, my lord,
Hmm.
that is the offered land.
Hmm.
And this offered land, in this offered land, my lord, there is no share of the others, assuming co-owner is not there, co-owner share is not there, identified.
But at that point of time, when you submitted the document,
No, my lord, I understand the purport of that clause, so that tomorrow there is no difficulty. But on the date when they took the decision, my lord, everything was very clear. At least in paragraph 6, we have made,
but if
I
the,
appreciate, my lord.
but if the tender document categorically says that the document has to be submitted at the time of here, at the
Well,
time of
well,
submission.
I can't say no to that, but here is a case where perhaps corporation could have taken note of it. It's not that, my lord,
Then it has to amend that, giving liberty to everybody to submit.
Others also. Other category one.
and my lord, this affidavit was there, page 45 affidavit, which was by that lady, my lord.
And paragraph.
But that is not in the format. That is why I asked him to place the annexure 3.
Paragraph 4 of that affidavit at page 46, my lord.
Pattadas, namely so and so, and my
But,
brother who applied for lease and so and so, so and so, so and so.
Any dispute? There was.
No objection.
No objection.
My lord, the purpose of that clause is met. Yes, in form, my lord, we have not complied with, that is a fact. Whether in the circumstances, my lord, an exception can be carved out. नहीं बोलेंगे एक
Nine.
If your lordship would kindly come to page 137 for a moment, my lord.
Yes.
That clause 3,
Hmm.
that in case he, she, so and so is selected for RO dealership, I will either sell, transfer, lease the above mentioned piece of land to oil company or to Sri so and so for setting up retail outlet facilities at the above mentioned location as per the site plan duly signed by me, all co-owner. In case of lease, I further confirm that I have no objection. So at least this way, this affidavit is there, my lord.
But as on that, there was no partition, huh?
That is a fact, my lord, that I am not.
That in the affidavit is already mutual family partition was.
And my lord, page 46, para 3, it also speaks about the mutual family partition, my lord.
Plus.
And my lord, para 5, this affidavit is meant for the purpose of partition of my share upon the plot of land measuring in my name and have no objection from any side for lease out the share portion and of land 1 bigha by so and so, and it shall be submitted before the authority concerned as and when required.
Yeah, file your affidavit.
Yes, I filed an affidavit, my lord. I have a copy of this, thereof. Till it comes on record, my lord. Let me.
No, my lord, I'm not disputing strictly things are not there. But perhaps they can take note of this and my lord, without causing any prejudice to the corporation, my lord, they can proceed. Yeah, okay,
No, this will be this court tinkering with the terms and conditions.
Lordship can leave and let them take a call in view of the attending facts and circumstances, my lord. End of the day, their purpose is to secure their interest, which stands secured. And it is in that context, my lord, I am making that submission.
Because once they do, there are other people who will be coming.
Let them take a
They may also have a right.
let them take a call, my lord.
How many people are there? Who is in grade class 1?
Hello, this at the last page, page 18, there are group 1, 1, 2, 3 other at serial numbers 3, 4, and 7.
No, whether they stand on the same footing.
No, there are 3 groups.
Yes.
Category 1, category 2, and category 3.
3.
Category 1 who has the land.
They have the land.
Either he can sell it, ownership or lease of 19 years, 11 months. Second is category 2, who has the confirm order or an MOU to that effect.
Farm offer.
And firm offer. And number 3 is who is going to find out after if he gets it.
Yes.
Yes,
That's-
they have no land as
No
on date
land.
of that.
So these are the 3.
Three.
Now you have relegated the petitioner to number 3.
3. So
And in draft lot, we have come out, my lord. The draft lot process is over. That we have overcome.
Drop lots
Yes,
over.
yes.
And after
After-
election, the land.
draft lots, after draft lots, the verification is conducted. And that verification, this matter came up regarding the existence of the co-owners because the application does not mention about the co-owners. And the lease deed also,
And have you made those people a party?
no, man.
Because.
Why?
We're not aware. Okay.
Why?
We got only now, because of the affidavit, we got to know, we have come to know. Otherwise, we are not aware of this.
Are you telling me that you didn't know how many persons were there in the category 1? Because
No.
their rights would be affected. If I pass an order without hearing them, because they will also have a right to say that, look here, these drop lots should have been like this.
No, draw of lots, lordship, it already happened.
Understood. Now, the moment it goes back, they are again going to have a drop lots for category 1 because you are disqualified. They are not going to go for category 3. They'll go for 1. Now, they have therefore, get an expectation out there that if this decision stands, they will get a further chance.
To that, if I may submit, lordship, the going to the next category, what we are challenging is that the very process of that they went to the next category, disqualifying us, is wrong, as per our submission. This is where we are, that's why their
Mr.
right should have.
Mr. Das, kindly understand. When category 1 person has been already made on the basis of drop lots,
Lordship.
and you having failed to produce it, now you are being relegated to category 3.
Three.
Means you don't have a land.
Yes.
Whether you could have been gone to category 3 is a different thing. Taking into account all these things, you should have been in category 2. Whatever I mean. But the fact remains that though they will then have to again go back to category 1.
Yes, madam.
And therefore, those 2 persons will again have a right to participate in category 1 because because a person who did not have the qualification, he participated. So they will again go to category 1. So those 2 persons will be affected They will be obviously supporting this decision.
At that relevant point of time, obviously, we did not have information.
You knew it because there were only 3 persons in the drop lots. You were very much present in the drop lots. 100%. This is not the first case I am taking up Indian Oil matters. Indian Oil, BPCL, all these things do the same thing. So therefore, you will be present when the drop lots happen.
Their information,
We do one thing. We issue a short notice, no stay. We'll issue a short notice. And as you have already filed the affidavit, giving them an opportunity to file the reply, we take it up, finish it off next week.
Any decision taken will be subject to the outcome of the case.
You know, when this court is dealing with it, they will take it. And one of your grounds will be to dismiss is non-joinder of necessary parties.
We take care of.
Issue notice making it returnable on 21st of August 2025 at 2 p.m. Mr. Why are you making the deputy commissioner a party?
Deputy সঙ্গে কে পার্টি করতে হয়?
This is a very sad type of petition, Mr. Chaudhary. Your junior has drafted it horrendously. You make them a party like this. District deputy issue notice making it returnable on payment. Mr. N. Bulwa accepts notice on behalf of the respondent number 1 and 2. As Bukoyal appears on accepts notice on behalf of the respondent number 3. Extra copies of the petition be served during the course of the day. Mr. N. Bulwa submits that the affidavit in opposition have already been filed on behalf of the respondent numbers 1 and 2. Mr. N. G. Bukoyal submits that he will take instructions in that regard. First of, liberty is given to the petitioner to file objection and file reply to the affidavit in opposition in the meantime. First, an attempt shall be made to dispose of the petition on the next time.
My lord,
Instead of 21, could it be 19 minutes?
my lord, 19, if possible. Certainly.
Is it Tuesday?
19, how many matters I have?
On 21st, that APSC series is fixed, I'll be slightly tied up. One series has been fixed on 21. 19th, Milord, or
19, please.
any other date
18.
convenient? 19, no, right?
18th also, my lord.
No. Hello, on 27th.
27th.
Then I don't fix the time. 27th.
Deep,
26th. 26th.
Tuesday.
Item 4. May it please your lordship. My lord, I have challenged the benefit.
Sorry, there was one matter in this lease. I have passed the judgment in your one of your cases.
Yes, my lord.
But is it reported anywhere?
Yet to be reported, my lord, it will be reported.
Reported.
Head notes have been written. Head notes have been written, my lord, and it is.
I just ask your junior to give it to me because this has any connection with the other matter.
Yes.
Yes, because there I have dealt with how it is to be
Yes,
done.
my lord. I'll provide a copy
Yes.
tomorrow.
My lord, the impugned notice and order at page 152, my.
What are you challenging?
My lord, they have threatened to deduct from my PDA account, that is the pre-audited debit balance account, the amount which is lying with the respondents, my lord. That your lordship will find at page 152
Consider the partner promotes in a heavy court is found. Side of right.
152, my lord. My lord, prior to it, my lord, to challenge the so-called notices, I came before this honorable court, my lord. And this honorable court passed the order on 17/3/2005 at page 125, whereby the honorable court allowed me to obtain these documents from the department. Accordingly, I requested the department to supply me the documents, and those documents were not supplied to me. At page 125, my lord. And it starts at page 129.
So you submitted your reply.
Yes, my lord, I demanded the documents, my lord.
Did you
And-
submit the reply?
No, my lord, because in absence of the documents, I could not submit the reply. My lord. I requested them to supply me the certain documents, which your lordship will find at page 137. And relevant is page 139, my lord. 139, my lord.
But that is not what the coordinate bench observed. Kindly come to paragraph page 135,
135.
paragraph 4.
I am confused.
It is the case of the petitioner, the respondents are yet to respond to the replies made by the petitioners, and in the meantime, the petition number 2 have been issued notices. Then he submits that the petitioner could not have filed a joint duty inasmuch as the cause of action is different. Considering the submissions made by the learned counsel, at this court proposes to dispose of this writ petition, directing the petitioner to grant an extension of directly the respondent to
30.
grant an extension of 30 days to date to the petitioner for making their replies to the communication made to them. The petitioner shall file the individual reply before the concerned authority within the extended period. May also supply any document that the petitioner may ask for to enable them to submit their reply. Till the reply is filed within the stipulated period of 30 days, so Iman, and a decision is taken by the concerned inmate here that there shall be no deduction. While considering the reply, they are liberty to give a personal hearing to so and so. Now you sought for some documents thereafter.
Yes, my lord.
Yes.
That your lordship will find at page 120, 137, my lord.
Ah.
And relevant is at page 139, my lord. Similar letters, my lord, or the petitioners.
How many petitioners are here?
There are 12 petitioners.
Huh?
12.
All are having the same cause of action.
Yes, same code of action, my lord. All are the distributors.
All are issued
all are-
one notice.
Yes, similar notice.
No, one notice.
Not one notice.
We
similar
dismiss it
notice.
on that. Non-joint. Individual cause of action cannot be done. We dismiss it. With cost of how many petitions?
There are 12 petitioners. my
Okay, 5,000 each for a month, so 12,
The
60,000.
The cause of action. is
DLSA will get 60,000 good. 60,000 cost. You cannot. Last time Mr. M.K. Chaudhary has clearly pointed out that aspect of the matter, but then also last time the court was very magnanimous out there, but I am not.
Paragraph 5, it was noted, my lord.
Why are you again filing the same type of petition? You have these are specific cause of action. You cannot come up with all this type.
My lord, the notice.
Okay,
So far
60,000 upon you, not to the clients, upon Mr. Bhatti.
My lord.
You pay.
Nay,
You pay 60,000 before the court, then I'll take it up. This type of matters, you know it. These are all individual cause of action. Everybody has been issued separate notices. You are to submit individual replies.
My lord, but in spite of that fact, your lordship will come to at page, first of all, I am taking to your lordship at page
I'm not going to look
152.
into all these things.
What-
On this
what-
ground, I am dismissing.
152, my lord.
No, I'm not looking into all this. This is the ground for dismissal. Take a dismissal on this. As a deterrent. Next time such action there would not happen. Chalo. Yes.
My lord, the similar petition had earlier.
Tell me what document you asked for? Did the petitioner number one ask for?
Specific.
No, wait. What
Yeah.
did the petitioner number one which document the petitioner number one?
Asked for equipment return vouchers, my lord.
Okay. What did the petition number 10 ask for?
The same document.
Now specify which are the documents you are saying. Let us see.
That is a specific I have given in my reply, in my application, my lord.
37.
At page 137, at
You are asking
39,
for these vouchers.
39.
With reference to the demand of the ERB are signed by either PSJ and also the furthermore, you are requested to send the document relied upon by you in your alleged notice. You are requested to allow us 30 days to give us suitable reply to the matter related to the year back until physical copy of the document is being supplied to us by already state the matter for 30 days. On 24th of the month. Report of March. Mr. Bhatti, you got the order on 4/4/2025. And
Two orders,
you
ma'am.
are referring to page 137, which is of 24th of March?
Yes, my lord.
How?
There are the two orders of the Honorable High.
I'm not concerned. I'm concerned with this, where
There-
you are appearing.
There are the two orders, my lord,
We
of
are
this
concerned
Honorable
with
Court.
this.
I have annexed both the orders, my lord.
Are all these people a party out here in one with petition?
Yes,
Then-
many persons were the parties
No,
in
no, no,
these
no.
petitions, my lord.
No.
Order, that is 17/3/2005. My lord, I am referring the only one piece.
Yes, agency.
17/3.
Agency.
That is there, my lord.
Where is PS Gas Agency? Where is PS Gas Agency?
Yes.
In which petition earlier?
Yes, my lord, this,
Yes. PS Gas Agency, page 132, in that order. And that order is 4/4/2025. You are referring to a document of 24th of March. How is it possible? Kindly see, page come to 133. 133. That is why you should not file this type of matters like this. Petitioner number 5.
yes.
Petitioner number 5
What?
got the order on 4/4/2025.
25.
You submitted this document on 24th of March 2025,
Yes.
meaning thereby prior thereto. Now the question is, this court directed you that, okay, you may ask for documents. Where did PS agency ask for documents?
My lord, prior to it, my lord, I am taking to your lord.
Prior,
You-
there is a
your lordship-
direction, you
My-
could have asked for documents.
My lord, I am taking to your lordship the earlier order
Yes,
at
that-
page 125.
Okay, all these are.
Pursuant to that order, my lord,
Prior to
there
20.
might be, my lord, some technical mistake in
There's
writing
no
the order.
mistake. These are all mistakes which have happened now. These
The
are
similar orders have been passed, my lord.
10/6. You were given 1 month time. That is why the problem arises. You were given 1 month time to submit.
Yes,
Now, if you wanted to seek a document,
yes,
you should have done immediately thereupon.
yes,
Now, yes, wait. The order was passed on 4/4/2025. You asked for a document on 10/6/2025 after the expiry of 30 days. Kindly come to page 148. I think it is 1,20,000 cost.
140.
60,000 is too less.
Next.
No, my lord, it is in the reply of the next notice which has been issued. Which has been issued, my lord, your lordship will see at page 147 regarding fixing the date of hearing. Against that particular letter, I gave the reply, my lord.
No, these technico submitted a document prior to this, checking for documents. Where is that?
Yes, my lord, I made the application, my
Where?
application. Those are at page, my lord,
Well, as
130
regards technico.
139.
Now kindly come to page 139. 139 is for which?
139.
That is for Sikha. I'm on technico. Kindly come to that petitioner who is technico.
139, my lord, it is.
The problem which
Sikha.
happens, Mr. Bhatti,
The
is
next
filing
one.
this type of writ petitions is that in each matter may not have the similarity of the facts. This is a case where you have asked for on 9th of June after the period of 1 month being over. Mr. Chaudhary, what do you have to say?
LPG distributors.
Mr.
My lord, the
Mr.
next one.
Chaudhary,
Your-
what do you have to say?
My lord, they were given a personal hearing, my lord, they did not count.
Matter over. No case. Dismissed.
And too
Better
many-
withdraw and file a fresh one for everybody. Giving details, not like this.
Makes very clumsy, my lord. Too many persons.
Absolutely clumsy. And pay 1,20,000 as cost for Mr. Bhatti. Do something good for the society. I'm not taking the money and neither Mr. Chaudhary is going to.
Also other ways, my
You
lord.
go to the DLSA.
There are also other ways, my lord.
Huh?
There are also other ways where we have to do good things to the society, my lord.
But this is not the way. But Mr. Bhatti, this is not the way you file a petition.
My lord, earlier I filed. those-
Earlier was a very kind judge, unlike me. And you have been unfortunate from bench one, I've been put here.
No.
Now
it
in a
is not
suit,
the-
now just for example, you are a very expert in civil law. Can you have maintained a suit like this? No.
Yes, my lord,
No.
but the older one.
No. Mr. O.P. Bhatti, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the cause of action of the petitioners, of the 12 petitioners are separate, you would withdraw the instant petition and without prejudice to the rights of the petitioners to file a fresh individual petition, respective for individual petitions on behalf of the petitioners. Mr. M.K. Chaudhary, learned counsel, appears on behalf of the Indian Oil Corporation. Taking into account the above, the writ petition stands closed on withdrawal, which the liberty, however, is given to the petitioners to file individual writ petitions if so agree as regards their cause of action.
I.
As regards the decisions so made, taken by the respondent corporation. Yes, Mr. Todi.
My lord, delay in disbursing the subsidy, my lord. Payable to the petitioner.
Delay in
Disbursing the subsidy, my lord. In fact, my lord, this is the,
how much delay?
my lord, lordship may kindly come to page 47.
What is the subsidy? 2003.
But policy was 2003, my lord. That was very for 5 years, my lord. Then within the time, my lord, the eligibility certificate is issued, which lordship find at page 47, my lord. So on 3rd June, from 8, my lord, the eligibility certificate was issued, my lord. Then, my lord, pursuant to the policy, my lord, the claim was filed, which your lordship will find
Wait.
at page 59.
You are a new industrial unit?
My lord.
Are you a new industrial
My
unit?
lord.
You set up your industrial unit when?
For commercial production, that my lord, it was started from 12 April 2007, my lord, which lordship find
April
page 47, my lord.
2007.
page 47, my lord, that is the LU certificate.
April 2007,
My lord,
commercial production.
my lord.
Okay,
So,
then
this
you
one
are,
is
you are
in
claiming
conformity with the policy, my lord.
subsidy in respect to what?
But then, my lord, what happened, my lord? It is in conformity with the policy, my lord.
Huh?
It is in conformity with the policy, my lord. Then, my lord, after the lodging the complaint, my lord, claim, my lord, reminders were issued, my lord. The reminders issued, then, my lord, they-
Dr. Todi, first of all, you are claiming subsidy in respect to what? It is an industrial policy. There has to be certain notification schemes and all.
my lord,
Which one?
But this.
In respect sales tax?
My lord, no, my lord, industry policy, for industry is concerned, my lord, number of packages are given, my lord, sales tax exemption also. But so far, my lord, the petition is concerned, my lord, where, my lord, it is delay was caused with regard to the, my lord, captive power plant, my lord.
Okay.
Captive power plant by subsidy, that 50% is entitled to, my lord.
Okay, where's the industrial policy for that?
But lords will probably find page 23, it starts from 23.
No,
Next
that
one.
is the industrial policy. Where is the for captive power?
My
Which is the
lord, page 34, my lord, page 30,
page 34.
my lord.
State capital subsidy.
3.4,
Huh?
close 3.4, my lord.
3.4. Subsidy on captive power generation. 50% of the cost of generating is set to the eligible industrial will be provided subject to the ceiling of rupees 10 lakh per unit. Okay.
My lord.
So then,
My lord, what happened, my lord, pursuant to this,
Hmm.
policy, my lord, the LU certificate was issued to us, page 47, annexure 2, my lord.
here, page 47.
Yes, my lord. My lord,
One time, it is given at page 48, number 3, subsidy on captive power generation, one time.
my lord. My lord, then, my lord, pursuant to the, my lord, policy, required, my lord, the ultimately, my lord, the scrutiny is made by the state level committee, my lord, which will also find at page 39. The
Page
39 of the policy, my lord, page 39.
9. Yes, this is the same.
This is the, my lord,
Now,
state level
you
committee.
booked for 11 lakhs 24,000.
My lord, my lord, yes, my lord,
But you are entitled to 10 lakhs.
yes, my lord. But with regard to the all the policies, my lord, but these are finally scrutinized. But state level committee, my lord, is the highest committee, my lord. But which is, my lord, the comprising of the persons, my lord, enumerated in the state level committee, my lord. Then what happened, my lord? They after receiving the reminders, my lord, they issued a letter to us. Of late, my lord, they issued a letter. Page 65. Lordship may kindly come to page 65. That was, my lord, with reference to the merit, my lord. With reference to the above, we are to inform you that your proposal was placed in the state level committee for AIDC for grant of fiscal incentive under Industrial Policy of Assam 2003, and after detailed discussion, the committee decided to re-examine the same in respect of the following: whether the DG set are environmental friendly.
So you comply with it by page 66.
My lord.
Then
We compared with, my lord, that we have said the next page, page 66, that, my lord, is all the 3 points were adequately replied to, my lord.
and then also they have not paid.
No, my lord, they have not paid, then they're sitting over the matter, and the reminder was issued. Then, my lord, what they did, after, my lord, continuous reminders issued to them, they finally, another letter, my lord, which lordship find to it, annexure 8, page 81, my lord. They again, my lord, they write a letter, my lord, which your lordship will find page para 3, second, last few lines, my lord, that the application was scrutinized and placed at the meeting of the state level committee under IPA 2003 held on 31/2016. The committee put up 3 queries, out of which 1 query is whether the unit has obtained consent to operate DG set installed at the unit. In this regard, as a part of this scrutiny, the application and update certificate of consent to operate is required by this office. You are therefore requested to kindly provide us with the views, comments on the aforesaid query depicting.
Now the pollution is not giving you the details.
But policy, my lord, is aware that when the pollution, pollution is concerned, my lord, it is renewed year after year, my lord. This the, my lord, so my lord, so far the policy is concerned, my lord, so far as the renewal is subsequent action, my lord. So, but that is not the basis for which my lord they can sit over the matter. But renewal is definitely, if they run the industry, they have to renew it. And it is renewed always.
Has it been renewed?
Yes, my lord.
It has been renewed.
Yes, my lord. It is renewed. Otherwise, the industry will, my lord, the unit will not continue, my lord.
Okay.
So
Have you
now-
have you enclosed the renewal?
No, that was, I have not, because they have wrote the letter to them only, my lord, to additional.
Understood. Have you enclosed the renewal? Because you must have taken the renewal prior to that.
No, my lord, what happened, my lord? In fact, my lord, so far as the, my lord, earlier when the query was posed to us, my lord, all the three queries were adequately replied to.
And you have given all the reply. Now they are still not paying and then they are making queries after queries.
Yes, my lord. Yes,
So
my
that
lord.
therefore the question is, as of now, this query is being made and thereby it is delaying the disposal, your subsidy claim. That's your case.
Yes, my lord. But now, my lord, only my lord, since subsidies, my lord, your lord is aware, my lord, I need not, my lord, sell all those things, my lord. But it's for a public purpose is to be achieved, my lord, but they cannot sit over the, for reasonable cause, yes, my lord, they can sit over the matter for reasonable cause. But unreasonably, my lord, they can sit over the matter and delay this process, my lord. So, my lord, they should process the matter, my lord, and can sanction and disburse the amount as entitled to, my lord, by the petitioner.
Industries department you have made,
Yes,
managing director,
But
no
they are-
pollution.
Police, my lord,
Not
national
necessary.
is not the party, my lord, they are not the, my lord, any hindrance, my lord.
Issue notice making it returnable on 24th of September 2025. Who appears?
I will appear, my lord.
Mr. So-and-so appears and accepts notice for 1 and 2. Extra copies of the writ petition be served upon him by Wednesday, date to deliver 6/8. The case of the petitioner herein is that in pursuant to the Assam industrial policy, in pursuance to the industrial policy of Assam 2003, the petitioner had set up its industrial unit and commenced commercial production on 12/4/2007. The petitioner was also issued an eligibility certificate on 3/6/2008, whereby the incentives in respect to which the petitioner was mentioned to be entitled to were sales tax exemption, power subsidy, subsidy on captive power generation, and subsidy on drawal of power line. It is seen from the industrial policy resolution, the industrial policy resolution 2003, more particularly at clause 3.4, that the subsidy on captive power generation is given to the extent of 50% of the cost of generating set to the eligible industrial unit, subject to the ceiling of rupees 10 lakhs per unit. It was all the petitioner, accordingly, after obtaining the eligibility certificate, made a claim application on 18/7/2008, seeking subsidy claim for generator subsidy, DG set. The record further reveals that in the year 2020, after almost 12 years, the respondent number 2 issued a notice to the petitioner seeking various queries. Full stop. In the year 2000, after 12 years, the respondent number 2 by the communication dated 9/12/2020 sought for certain queries from the petitioner. Full stop. The petitioner duly replied to the same immediately, along with all the supporting documents. Full stop. The petitioner expected that on the basis of the said queries, the petitioner's claim so made would be granted. Full stop. However, again on 19/4/2024, after another 4 years, the respondent number 2 have sought for certain clarifications from the Pollution Control Board. Full stop. The petitioner herein has approached this court on the ground that for the last 17 years, huh? Last 17 years, the petitioner's claim in respect to the for subsidy on captive power generation have not been granted, which on the face of it appears to be granted. The learned senior counsel appearing on behalf of the petitioner submits that on the basis of the assurance so given in the industrial policy of Assam 2003, the petitioner had set up its industrial unit and had made investments for no rhyme or reason. For the last 17 years, the petitioner have been deprived of the benefits. The respondents are directed to file their affidavit by 15th of September 2025 as to why till date, the petitioner have not been granted the benefit of the subsidy, more particularly on captive power generation. Liberty is given to the petitioner thereupon to file reply if so advised.
Much obliged.
Item 6.
What, devoter?
Yes, Lordship. Since 2005, my name has been marked devoter, Lordship.
2005, you are a devoter.
Yes, Lord.
What are you doing all these years, 20 years?
Yes, Lordship, I approached before the concerned authority, but there is no any reply. Kindly see the page number 20, Your Lordship.
I marked the LSC and Superintendent Police border.
Voters late 2005, 39 dollars. Dispose of.
Obliged.
Dispose of.
Item 7.
Not order.
Maybe Lordship.
What is this?
My case is that the petitioner is the one of the tenderer, my lord.
Huh?
Tenderer, my lord.
Ah,
The regarding number 13, no, my lord, 13 tenderer participate in the, my lord.
tender,
process.
no, name of the tender?
My lord, Girikanto Das, tenderer.
Very nice to hear the names of the tender.
And fishery name, my lord, number 13, no, mean
Number 13 settlement, not 13 number, Nonoi Mean Mohol. Okay, then what happened?
My lord, the tender process was completed, my lord. The petitioner from respondent authority come to know he is the highest bidder, my lord.
Who?
The petitioner, my lord.
The highest
Company-
bidder.
Yes, my lord.
Now
But-
they don't want to give it to you.
No, my lord.
Now they are going for a fresh tender.
Yes, my lord. We have submitted a representation before the concerned authority being a high bidder settled to fishery in favor of me. But without anything, my lord, they issue fresh tender immediately, my lord.
Instruction, my lord, why it has been done, my lord.
Hello. Issue notice making it returnable on 18th of August 2025. Stop. Extra copy, Mr. So-and-so appears and accepts notice on behalf of the Fishery Department. You is there? Yes, you. You are there, Fishery Department.
Lordship, yeah, maybe. Say government.
Thank you. Yes.
Maybe it was withdrawn because of the order passed by the Supreme Court, Lordship.
What there happened?
Because they have asked us to put a 2008 notification in all the tender bid. Directed.
You have it?
Yes, I could not.
Okay, we'll have it at 2. At 2? You bring that instruction, huh?
It is here.
No, you have it, just bring it, there too,
Lordship.
and close this.
Item 8.
Under the termination of contract, and I'm conscious of the fact that there is an arbitration clause, but there are two short points, Madam. One is we are questioning the jurisdiction and jurisdiction itself of the, if your lordship will kindly come to the termination order, Madam, at page 386.
Yes.
386, your lordship will kindly see who has issued one, executive engineer. And if your lordship will kindly come to 328. I'm not troubling your lordship with the merits of the issue at all.
Have you started any work?
Yes, madam. What had happened? This is a land which requires house filling of about 4 meters. They initiated a tender process for earth filling, which tender process never got concluded. And this contract of construction has been awarded to me. After more than 1 year, they say that open foundation will not do, you will have to do pile foundation. That drawing was never finalized till April 1. Those designs, because there is a separate consultant for the design. We were handed over and we were verbally.
Now tell me, why should this court interfere?
There are two grounds, primary grounds. First is jurisdiction. Your lordship will just make a note of two things. One, the date of the order, 30th of May, and down below your lordship will find executive engineer is the issuing authority. If your lordship will kindly come to page 328, the termination clause. (328).
Yes.
In the middle, your lordship will find when contract can be determined. Subject to other provisions contained in this clause, the engineer in charge, your lordship will kindly note this one. Engineer in charge may, without prejudice, etc., can determine the contract. I am not again troubling your lordship with the merits as such as yet. If your lordship will kindly turn to 322, engineer in charge has been defined. Page 322. Clause 6.
Chief engineer who shall be in charge of the work that shall.
The engineering charge means the chief engineer, and the term chief engineer means chief engineer PWD building. So first ground is jurisdiction. Second is, my lord, if your lordship kindly comes back to that order of termination at 386, your lordship has noted the date, 30th. The notice was issued just one day before. We did not even get an opportunity to respond.
Where?
Page 384.
Letter. Just 1 minute. Let us see the earlier one. This is also 29. What is this final notice basically?
They say, call it the final notice, but there is no prior notice before this. We were never asked to show cause.
Where is the termination clause again? Yes. Okay.
And your lordship will find that clause 2 provides for 7 days notice. Subclause 2. This is, we stopped work for 32 days. And we have annexed all those. I am not troubling your lordship with the merits. There's incessant rain. We could not have done a pile foundation.
Yes, Mr. Gogoi.
First of all, if, as Lordship has stated, my lord, there is arbitration clause, otherwise they can, my lord.
Understood, but this makes no sense.
29.5, my lord, notice.
But one is 29.5. You give him notice, whatever may be. And secondly, it has to be done by the authority concerned. Huh?
Might be delegated, my lord. to
No,
the-
you cannot delegate when the contract says. Better, I think you should concede.
But my lord, the new tender has been floated
So
in
what?
July, 20th of July. Just I'm saying, my lord.
You take a decision on a call, you have to cancel the year.
My instruction is they have not uploaded.
The reason why I'm saying it, a stay here
Lordship,
is going to affect your work.
yes, otherwise.
It is not going to make any sense. I think you withdraw this thing, both of them, and go for the fresh one. If you want to take a decision, take a decision.
Let it be on Friday or Wednesday, my lord, 1 day's time, just to have the instruction.
2 o'clock. 2 o'clock. 2 o'clock. 2 o'clock, you would only take that instruction in writing. You take that you are going to take a fresh decision on this. That it
Yes,
will
in
be
fact,
done
my
by
lord,
the
after this, my lord, they have submitted a representation at page, my lord, 387, explaining everything. So what decision they have taken?
They have state many things, but this is the basic.
Yes,
The
others
the
of the
contract
authority.
termination can only be done by the chief engineer, executive engineer
Might-
cannot. So
Lordship,
you take, because you see, if I have to do it, I have to issue notice because this is a termination by an authority who is not authorized.
my lord.
So for that I have to state. If this stay is given, it is going to hamper the work,
Yes.
which I don't want.
Yes, my lord.
So by
Otherwise-
2 o'clock, if you come at matter solved,
Lordship, I will do.
Item 9.
yes, what is this?
My pleasure. Your Lordship. Herein, NIT was issued, your lordship, for settlement of market, your lordship. And the petitioner, he had submitted his application to get settlement of producer daily market, your lordship.
Then
Then thereafter, the tenders applications were opened and the tender application of the petitioner was found valid. And the respondent and since the
what
tender,
happened to your tender?
my tender was in the first NIT, your lordship, my tender was found valid. But without settling the market to us, they have again issued another NIT, your lordship.
So we are not concerned with first. First is gone.
No, first, I am concerned only with the first. Because in the first NIT, your lordship, we have submitted our NIT and it was found valid. So they need to make settlement, your lordship. But instead of settling the market,
Where is the fresh one? Have they cancelled the early one?
no, they have also not cancelled, your lordship, but
Where? You are challenging the second one.
yes, the first one is at page 22, your lordship.
You are a valid tenderer.
Yes. And the second one,
What market?
Budusar daily market, your lordship.
How do we know that you are the highest bidder?
Because the tenders were opened in presence of the petitioner, your
Where is
lordship.
the comparative chart?
No such comparative chart has been prepared there.
How do you know that you are the highest bidder?
Because the tender applications were opened in presence of the petitioner, your lordship. And some other
How
bidder.
much did you quote?
We have 22,14,889, your lordship.
You are the highest bidder.
Yes. Yes.
So they've cancelled it.
As for the petitioner, my lord, except him, my lord, others bids were invalid.
So
Is the only
one
valid.
bid was valid.
Only his bid was valid as per his statement, my lord. And there was a clause, my lord, in the NIT itself that if the amounts are lower, my lord, they can go for retender. So short notice may be fixed the matter, my lord. Lordship may fix the matter on next week. I'll take the instruction.
So the next week is when? NIT of 25/7. When is the last date for submission of the bid?
6 August.
6th of August, I think Wednesday, so we have to state this.
My lord, maybe on that day, matter may be fixed.
6th of August, then also we have to state. What do you say?
Because,
Okay,
my lord,
let them proceed. Let them proceed, but not to
not to finalize the deal.
finalize.
If that means your lord.
Let them proceed, but not to finalize. You submit if you feel like.
He can also participate, my lord. Yes.
But herein your lordship in
Without prejudice to the writ petition, you can participate. That I'll make
But
it
I think
clear.
it will better your lordship if we'll keep pending your lordship in respect of that market your lordship. Others we have no concern your lordship. I am saying that only in respect of Budusar Delhi market your let it.
You give an undertaking then? The entire cost of the tender process for a fresh one you will be paying if you lose the case.
Yes.
Give an undertaking. You'll give an undertaking. All the entire expenses which is being borne for a fresh tender process. If you will win, well, very good. But if you lose, you pay.
But I am saying only because of that your lordship, if the petitioner.
Therefore, let it proceed. But no decision be taken. I'll have a short notice.
My lord.
Issue notice. We have it next week.
My lord.
Issue notice making it returnable on 18th of August 2025 at 2 p.m.
But for respondent number 3, he has to serve dusty, my lord, because president is there, my lord.
Who has issued the notice?
My lord,
4 year.
Huh?
Respondent number 4.
4. 4 you are appearing, na?
I'm appearing, yes.
We are not concerned with 3. 3 is not, has no business.
Yes.
What does 3 has to do?
3 is the president of that.
Jilabari.
Jila Parishad
Who
president.
is the tendering committee? It's 2, 4, na?
4 is the ex officio member, but the.
Who is the
also-
tendering authority?
Actually, 3 and 4 both, my lord. At that time,
No, who has
maybe
issued the tender?
the tender was issued by 4, my lord.
The 4.
But 3's responsibility is also there, my lord.
The responsibility, he has no business to look into it.
My lord, he is the president of that committee, my lord.
Mukhya Karyalayar Bikhoya will be the executive officer.
Yes.
Then, we should issue notice upon the respond number 1,
2 and 3.
2, and 4.
4, yes.
Mr. S. Dutta accepts notice on behalf of the respondent, said respondents, extra copies be served upon him during the course of the day. For the present, this court is not inclined to issue notice upon the respondent number 3. The case of the petitioner herein is that the Chief Executive Officer of the Gwalpara Jila Parishad had issued an NIT dated 5/6/2025 inviting tender application from intending persons for offering settlement of various huts, fishery, including Buduchor daily market under the jurisdiction of the Gwalpara Jila Parishad for a period from 1/8/2025 to 30/6/2026. The petitioner, along with other bidders, duly submitted the said bid. It is the case of the petitioner that the petitioner had submitted the bid higher than the government value of the said market. To the surprise of the petitioner, the respondent authorities, instead of settling the said bid, said tender, dated 5/6/2025 in favor of the petitioner, have issued another fresh tender on 25/7/2025, whereby the Buduchor daily market have also been put to sale. The petitioner is aggrieved by the high-handed action on the part of the respondents in not granting the settlement to the petitioner, in spite of the petitioner having quoted a high amount, and it is the also, and the petitioner have reasons to believe that the petitioner is the highest bidder in respect to the earlier tender process initiated by NIT dated 5/6/2025. Next. The learned counsel appearing on behalf of the petitioner further submits that if the present tender process is being initiated, he is being allowed to that the impugned tender process that is initiated by the NIT dated 25/7/2025 is allowed to proceed. The rights of the petitioner in respect to the earlier NIT dated 5/6/2025 would be nullified, and the filing of the instant writ petition would become infructuous. For taking into account the above, it is the opinion of this court that the petitioner is entitled to an interim relief till the next date. Accordingly, this court directs that the respondent authorities, more particularly the respondent numbers 1, 2, and 3, 1, 2, and 4, shall proceed with the notice inviting tender dated 25/7/2025, but shall not 25/7/2025 in respect to shall proceed with the notice tender process initiated by notice inviting tender dated 25/7/2025, but however shall not finalize its decision in respect to the judicial daily market till the next date. Full stop. This court permits the petitioner to participate in the said tender process. Full stop. The participation of the petitioner in the tender process dated 25/7/2025 shall not cause any prejudice to the petitioner in the present proceedings.
My lord, in the meantime, my lord, section 1055, it says, my lord, if not settled, department can go directly, run directly. That may be observed, my lord.
I'm having it on 18, finishing it. Oh. As of now, you have not done anything. I have not given anything. You have the act.
Yes,
You can
yes.
do everything.
My lord.
But you have got a new book. Let us see. You have been mentioning everything, new provisions. Has a new book coming?
Yes, my lord. No, latest not yet come, my lord. This is
Oh.
the last year's book, but thereafter many things have changed.
Many amendments have happened.
Yes, my lord.
Yes, Mr. Sahu.
Milord, my contract was cancelled without any issuing notice.
Hmm?
My contract, I was awarded with 2 works, Milord. And that was later on cancelled without issuing any notice to me, without defending my award, giving any opportunity to defend that award, Milord. Improving order are at page 136 and 37.
Earlier, somebody filed a petition.
My lord,
What is that?
that was, my lord, at page 133.
Similar thing.
My lord.
Irrigation. None from the irrigation. Huh?
But our irrigation department applied the case.
Their names have been shown in the court list.
Yes.
Did you perform any work?
My lord, no, I was not, my lord, allowed to work.
Why?
Actually, earlier somebody has raised complaint. So they asked me to wait sometime, and later on it was cancelled, my lord.
So you knew about that.
My lord?
You knew about the complaints.
No, I didn't know, but they said that somebody has made complaint and inquiry is going on. So I was asked to wait.
What complaints were there?
My lord, that complaint was not clear, my lord. Somebody has raised, my lord. Those are at page.
You were granted the contract, which one?
My lord.
Which contract? Where is your contract being awarded?
My lord. At page 38, boring and installation.
And was to complete within 60 days.
60 days, but I was not allowed to work, my lord. I was always asked to wait because of that complaint.
And you were ready to do at the same rate.
Yes, my lord, I was.
You made a statement in your petition.
No, not, my lord. If
Yeah.
required, my lord, by way of additional affidavit, I will.
Because if you don't work at the same rate, staying this process does not make any sense.
Well, otherwise I'll file additional affidavit if required.
Tender was issued on 12/3/2024,
Yes, 12,
isn't it?
1/8/24.
Huh?
Now, I was awarded on 1/8/24.
1/8/2024 will be subject to the availability of the fund and FOC received from the government. And these are short tender notices.
My lord.
Oh, I remember this matter. Where is the finance? Last time I asked about this matter came up on Friday, na?
Yes, my lord.
Friday. I asked about this thing as regards the tender because what they say that they had to go for an online bid. That is somebody who appeared from the irrigation department.
Lordship, give me some time, I'll inquire as to what
And
the.
Mr. Gogoi, I've asked him to obtain that instruction to that effect.
Okay.
Now, on the last occasion, he said that he is going to produce those documents to that effect.
Lordship.
There is a document by which they had to either above 20 lakhs, it has to go to the GM portal. And below 20 lakhs, it has to go through some online tender or.
Oh, yes,
something.
Lordship.
That is, has been mentioned.
Lordship.
Where is he?
Lordship, he's now gone to court number 1.
Hey, it was AC to somebody. We'll have it after some time because I remember this matter now. Yeah, and get the irrigation. We'll have it at 2. Ask him to be present.
Item 9 for admission, part heart. Sorry, item 10.
Can you see the last order 16/6 passed by
The order, my lord, the 16, may kindly be looked into, my sir.
The impugned order is at page 147. Annexure H.
But the suit was valued at rupees 20 lakhs 100.
My lord,
Suit was valued at rupees 20 lakhs 100.
20 lakh 100.
So as per that, the court would not have the jurisdiction.
Court hold it that court has no jurisdiction. Actually, the valuation, my lord, the caption, it was given as 20 lakh for jurisdiction and 100 for consequential relief. That was mentioned at the caption of the plaint, my lord. But in the body at page 20, para 28, he has mentioned it as a 20 lakh for declaration and 100 for consequential relief. And the court has clubbed together both the relief, my lord. And the thing is that, my lord, so far 21, section 21 is concerned, and pecuniary jurisdiction of the appellate court, my lord, that cannot be raised at this stage, my lord. Already it was disposed of earlier. Then there was a revision before this honorable court, and then direction was given. Now it is at the subsequent stage, my lord. So 21 is a clear bar, my lord, so far the pecuniary jurisdiction of the appellate court is concerned, my lord. And it was nobody's case. Even the court has so moto has taken it. Court has clubbed both the relief together by saying that it exceeds the pecuniary jurisdiction of the court. And may I read, my lord, 21(2)?
Yes. CPC yes. Yes, 21.
No objection as to competence of a court with reference to pecuniary limit of jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court of the first instance at the earliest possible opportunity. And in all cases where issues are settled or before such settlement, and unless there has been a subsequent failure of justice. So here, my lord, it
Now,
was a
this 21(2) will only come in
my lord.
if in a case the suit is filed.
My lord, if so far the court of the first instance is concerned, it has an unlimited jurisdiction, civil judge.
Understood. If you don't raise the objection there,
Yes,
for the purpose of the appeal,
yes,
appeal becomes the court of the first instance.
yes,
So there only you have to raise the issue.
yes.
Now the question is, no objection as to the competence with reference to the pecuniary limits of the heir shall be allowed by any appellate or revisional court unless such objection was taken of the court of the first instance.
Yes,
Now here the court takes the objection.
yes. Court has taken this.
So the court can very well look into it because that court is the court of the first instance.
Yes,
How will 21(2) come in?
but my lord, at the subsequent stage, man, already the appeal was once heard and disposed of. Then there was an
Did preclude the court to exercise the jurisdiction? Yes,
Yes.
you cannot raise an objection of either of the parties cannot raise an objection, but could it preclude the court from exercising the jurisdiction? Just for example, if we accept your submission, tomorrow a matter where our appeal had been filed earlier as per the earlier Bengal Agrab Act.
Yes.
And the appeal was lying before this court at rupees 10 lakhs.
Yes.
Appeal admitted everything.
Yes.
Then can this court still exercise the jurisdiction then? When, as per the new amendment,
That material.
it has been gone to the district.
Yes.
So here that, for that purpose, it does not preclude the court to do it,
Yes.
but it may preclude both the parties to raise them.
Parties to this.
That seems to be the interpretation of 21.
Yes.
So therefore, the jurisdiction which is to be for declaration, 20,000, 20 lakhs, which he has done.
Yes.
Is it required for 100 rupees to be separately valued?
Yes.
You don't value, because this is a suit filed under 7(4)(c),
7(4)(c).
which means declaration with consequential relief.
Yes.
So therefore, the court fee has to be paid as per the 2 lakh rupees.
Yes.
20 lakh rupees.
20 lakh.
Or 20 lakh 100 rupees. But
Yes.
you need to separately value the injunction.
Yes.
It is being done in some courts out there by lawyers. They do it to save it, and then for 20 lakhs they pay 22 rupees and 100 rupees. For 100 rupees
For
they pay
injunction.
11 rupees, and
Right.
then pay only 33 rupees in the appeal,
Yes.
which is wrong,
Yes.
which they can't do it.
Yes.
But it had to be paid around, on 20 lakhs, they had to pay 11,000 rupees.
Yes.
So if it is the suit coming within under 7(4)(c),
Fine.
then the valuation of the suit has to be, 100 rupees has to be omitted.
Yes.
The concept of separately valuing the
It's not required.
injunction does not arise, because it is simply a suit of the 7(4)(c).
Yes. And then maximum court fee is to be paid.
Would be 20 lakhs.
Yes.
Yes, Mr. Zamaria.
Lordship is quite right. Only one citation on this point. Lordship is rightly pointed out, separately not required, because ultimately the value that on the body of the top keeps it for further consideration. Lordship, paragraph 4, just only one my lord, paragraph I would like. The same situation has been dealt with. The declaratory along with the injunction, separate amount was pointed out, but it says no. And another Lordship wants to see consequential relief definition.
This is what I was saying also.
Yes, my lord. Lordship, otherwise Lordship prior to that also pointed out that in certain suit wherever 11 rupees for so and so, so and so, so and so, if clubbed together, it shows a different figure. But normally the registrar take into consideration whatever on the top of the figure, and well, accordingly the suit has been proceeded. Now, so far our default partition will fill up. There is no problem. Next date will deposit the amount.
Shall let me dictate that.
Secondly, my lord, this appeal was dismissed, my lord, on that ground.
No, I'm remanding it back.
Yes, yes.
Lordship, kindly point out this thing in detail because mostly that has confusion arises in that office, my lord. Sometimes the registry say, no, you have to pay separately. We point out this thing. Lordship, just make a very clear definition of this part, my lord. 7(4)(c).
Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner. The essence summary of the learned counsel appears on behalf of the petitioner and the counsel appears on behalf of the respondent. The supervisory jurisdiction of this court have been invoked, challenging the order dated 29/5/2025, passed in Miss Appeal number 4/2023, whereby the learned court of the additional district judge number 1, Kamrup Metro at Guwahati, had dismissed the appeal on the ground of lack of pecuniary jurisdiction. Before dealing with this decision of the learned of the first appellate court, decision of the learned first appellate court, this court finds it pertinent to take note of certain brief facts which led to the filing of the said appeal before the learned first appellate court. The materials on record show that the respondents herein as plaintiffs had filed a suit being titled suit number 765/2022. A perusal of the plaint reveals that the respondents as plaintiffs sought for a declaration, sought for certain declarations, as well as for permanent injunction and mandatory injunction. The permanent injunction and the mandatory permanent prohibitory injunction as well as the mandatory injunction so sought for in the plaint appears to be dependent upon the declarations which have been sought for in the plaint. Therefore, from the very framing of the suit, it would transpire that the suit would come within the ambit of section 7(4)(c). 7 Roman 4 small c of the Court Fees Act 1870, meaning thereby that it is a suit seeking declaration with consequential reliefs. This court further finds it relevant to take note of Section 8 of the Suit Valuation Act. Year to side 1870, na? 1870.
1887.
1887.
1887.
1887, which stipulates that the suit is to be valid it stipulates that you have a book. That when in suits other than those referred to in the Court Fees Act 1870, in valuation. Court Fee Act. 7-4 होगा, देख। Mr. Sharma, if we go into this,
Here, my lord, the four section 7(4)(c), 4 is not mentioned here.
no, 7-4.
Yes, but
It
in,
is not C. This is will come under 7-4.
yes.
7-4 for a declaratory decree and consequential relief to obtain a declaratory decree or order where consequential relief is paid.
Same.
7-4C, that is C.
Mas 7, my lord,
But here is
7-4C.
7-4C, my lord, correct.
C
yeah,
Yes, my lord.
is to obtain a declaratory decree or order where consequential relief is
It's
paid.
paid.
So now if we go by the Suit Valuation, Suit Valuation Act, which section will come into play?
section 8.
8.
How will section 8 come into the play? Where in a suit other than those referred to in the Court Fees Act? Section 7, section. Paragraph
7, 5, 6,
of
9.
The value of the area. So this is 7 as per 8.
Yes,
So it will come under section 7.
7. Section 7, paragraph 5, 6, and 9.
This is comma.
Yes,
So paragraph 5, 6, and 9. 5, 6, and 9. 6, 5, 6, and 9, and paragraph 10. What is that? Was the Court Fees Act are payable on envelope. Paragraph 7, 5, 6, and 9. Where do we get this paragraph 5, 6, and 9? These are all given in capital
yes.
and para 10.
Paragraph 5.
Is it in respect to here? Proceed. In declaration along with consequential reliefs. The suit seeking a declarative decree and consequential relief. This court now finds it very pertinent to take note of Section 8 of the Suit Valuation Act 1887. Which stipulates that the value as determinable for computation of the court fee in respect of a suit coming within the ambit of Section 7(4) of the Court Fees Act 1870 and the value for the purpose of jurisdiction shall be the same. Or in other words, the valuation of the suit determines the value of the court fee to be payable. And not vice versa. Therefore, the concept of valuing the suit for declaration as well as for injunctions separately, more particularly when the suit is a suit coming within the ambit of Section 7(4)(c) of the Court Fees Act, is misconceived. It is on the basis of the valuation of the suit the court fee is required to be paid. And the concept of valuation of the declaration and the injunction separately and thereby to determine the value of the suit is foreign to the provisions of the Court Fees Act 1870 and the Suit Valuation Act 1887. In the present, a perusal of the plain would show that the suit have been valued at rupees 20 lakhs and the injunction have been separately valued at rupees 100. Though the injunction so prayed for in the suit is dependent upon the declarations sought for in the suit and would come within the ambit of a suit to obtain a declaratory decree or order along with consequential reliefs. However, what is noticed in the from the perusal of the plaint, that the plaintiffs had made an admixture of section 7(4)(c) and 7(4)(d). Though section 7(4)(d) is only in respect to a suit purely based on injunction. Accordingly, it is therefore the opinion of this court that as the plaintiff had valued the suit at rupees 20 lakhs and the suit squarely comes within the ambit of section 7(4)(c) of the Court Fees Act, Act of 1870. The question of valuing the injunction separately does not arise. Next. At this, so before moving forward, this court have noticed that though have noticed a practice in the trial courts, and the present case and the present plaint is a testament of that. The practice so followed is the declaration would be valued at a particular amount and the injunction would be valued separately. By this process, the parties in the suit pay a paltry amount of rupees 22 for declaration and valuing injunction at rupees 100 pays rupees 11 as court fee. Though when a suit which is filed under section 7(4)(c) seeking declaration with consequential relief, the payment has to be made, the payment of the court fee would be dependent upon the valuation of the suit. And the court fee payable is ad valorem. Proceeding further, it is noticed that proceeding further, this court observes that the present suit, being title suit number 765/2000, 2022. The value of the suit, the plaintiff had put at rupees 20 lakhs. And therefore, there was a requirement of payment of court fee of rupees 11,000. A payment of court fee at the ad valorem rate, which as per the submissions so made by the learned counsels at the bar is 11,000.
It is maximum court fee, madam.
11,000, which is the
11,000.
maximum court fee.
Yes.
An injunction order was passed in the said suit by the court of the learned civil judge, senior division number 1, Kamrup Metro at Guwahati, in Mizze case number 1179/2022. Whereby directing the petitioners herein, their men, representative agents, etc. No, they passed an had passed a temporary injunction against the petitioners herein, their men, representatives, agents, etc., thereby restraining them from using the name of Ek Saran Bhagavati Samaj till the disposal of title suit number 765/2022. It is further noticed that an appeal thereagainst was filed by the petitioners, which was registered and numbered as Miss Appeal number 4/2023. The issue of pecuniary jurisdiction never featured in the said appeal. By a judgment and order dated 25/8/2023, the said appeal was allowed, thereby setting aside the injunction order passed by the learned trial court dated 21/2/2023 in Mizze case number 1179/2022. It may be noticed, it is pertinent to notice that the issue pertaining to the pecuniary jurisdiction never featured in the said adjudication of the appeal. The record reveals that the respondents herein preferred a proceedings under Article 2 to 7 of the Constitution before this court, which was registered and numbered as CRP number 138/2023. This court disposed of the said application filed under section Article 2 to 7 of the Constitution. 115 or 2 to 7?
2 to 7, my lord. Earlier we have found 115, but later on, my lord, it has been treated as
2 to 7. To 7. Thereby, setting aside the order passed by the learned First Appellate Court dated 25/8/2023 in Miss Appeal number 4/2023 and directed the learned First Appellate Court to decide afresh the said appeal However, without disturbing the findings which have been observed in the said order dated 14/3/2024. Item 13, 14, and 15 and 16 of the order, 16 not necessary, 13, 14, and 15 of the order dated 14/3/2024 being relevant is reduced hereunder. Next. It further appears that pursuant to the directions passed by this court for rehearing the appeal was heard, and by the impugned order dated 29/5/2025, passed in Miss Appeal number 4/2023, the learned First Appellate Court dismissed the appeal on the ground of lack of pecuniary jurisdiction. It is under such circumstances that the present proceedings have been filed. It has been submitted at the bar by both the counsels appearing on behalf of the parties that the question of pecuniary jurisdiction, lack of pecuniary jurisdiction, was not agitated by either of the parties before the learned First Appellate Court. However, the learned First Appellate Court, taking into consideration that the suit was valued at rupees 20 lakhs and the injunction was separately valued at rupees 100, and taking into account the same, held that the learned First Appellate Court did not have the jurisdiction, in as much as in terms with section 21(1) of the Bengal Agra Assam Civil Courts Act 1887, the pecuniary jurisdiction of the district judge cannot exceed rupees 20 lakhs. This court, in the foregoing segments of the instant judgment, had categorically observed that from a perusal of the plaint, and it appears, from the perusal of the plaint, it appears that the suit so filed was a suit seeking a declaratory decree or order along with consequential reliefs, and it would come within the ambit of section 7(4)(c) of the Act of 1870. The suit having been valued at rupees 20 lakhs by the plaintiff, the question of separately valuing the injunction does not arise, is completely misconceived. Accordingly, the suit has to be deemed to have been valued at only rupees 20 lakhs. This court, therefore, in that view of the matter, as the suit is valued at rupees 20 lakhs, it is the opinion of this court that the learned First Appellate Court has the jurisdiction, is conferred with the jurisdiction, pecuniary jurisdiction, to decide the appeal in terms with section 21(1) of the Bengal Agra Assam Civil Courts Act 1887. This court further takes notice that the learned First Appellate Court did not exercise the jurisdiction conferred upon it, and had dismissed the appeal by committing an error in exercise of jurisdiction. Accordingly, this court interferes with the order dated 29/5/2025, passed in Miss Appeal number 4/2023, and further directs the learned First Appellate Court to decide the appeal afresh, keeping in account the directions so passed by this court in its order dated 14/9/2023 in CRP number so and so, the relevant portion of which have been already quoted herein above. Full stop. Taking into account that both the parties are duly represented, they are therefore directed to appear before the learned First Appellate Court on when?
Next week, my lord.
Any date, my lord.
Next week, my lord.
Next week maybe. Next week maybe.
My lord,
We'll
can you fix the time period of disposal, my lord? Otherwise, it's again be delayed, my lord.
27th August?
27.
Oh no, today is only 4th, nah?
Yes.
On 18th,
My lord, no problem.
18, 19, 20.
18 maybe, my lord.
On 18th of August 2025.
Yes.
Full stop. The injunction order passed by the learned trial court dated 21/2/2023, passed in Miss J case number so and so 1179 Nicholas, shall continue till the next date, so fixed before the learned First Appellate Court. The learned First Appellate Court shall extend the same upon due application being filed. If so deemed, shall extend the same upon due application, upon consideration of applications duly filed.
My lord, the disposal, my lord, time limit of appeal, my lord. Otherwise, it again be, my lord, delayed unnecessary.
Whose appeal? Who has got the injunction?
No, my lord, but ultimately I know that what happened there, my lord. The last occasion, my lord.
I have given an injunction.
No, yes, my lord, that is.
Injunction is continuing. You were getting an injunction. I will last with you. This court further directs the plaintiff to deposit the additional court fee
Yes.
within
Next date fixed, my lord.
within 13th of August 2025.
Yes.
Before the learned.
Item 11.
Elevated tax. Well, notice was issued, my lord. The lordship will kindly see inviting tender, inviting my lord for desilting work, page 19.
What is this case?
For VAT, whether VAT is applicable, my lord.
To
Work was given, it is a desilting work. They've used tractors and desilted the agricultural field, and thereafter, my lord, payment has been made to the petitioner. Then thereafter, on the basis of the objection from the AG, my lord, bill has been raised to the petitioner saying that he will have to pay 14.5 lakhs towards VAT. My case is, my lord, VAT is not applicable because this is not a work, contract work, and this is not a, my lord, there is no sale in it, and they are not the registered contractors. So VAT is not applicable.
what?
They are not the registered contractor
If
because
there is no registered contractor, then there is no VAT.
there is no VAT. That
Why?
is the notification is there.
To me,
And there is no sale also because they have only cleared, my lord,
where is the notice?
DC.
VAT?
copy of the letter from that is at page 36.
Huh?
Page 36.
Page 36, yes. Regarding audit of with reference to the
And there is an order from this court whether there is any sale component in it. Order dated 12/9/2018.
Notification, sir. 2018. No, 2010. Lordship will kindly see the AG's affidavit also. Page number.
Yes.
Pages. AG's affidavit, paragraph 5.
This is a
Is the-
composition scheme. How
The
does the
notification, this is a notification. This is a notification under section 20 of the VAT Act.
No, this is for composition.
Composition.
How is composition relevant?
Relevant because it says that it is applicable only in respect of the persons who are registered contractor. And where
Composition is.
AG's
You are
letter,
being
your
asked
lordship,
to pay how
AG
much?
14 lakhs 50,000 at 5%.
No, at 5%
Yes,
of the contractor's bill.
yes. And paragraph
Yes,
5 of
the
the
VAT
AG's.
amount that there is. Yes, what is the amount? As per that contractor bill, how much it should be?
Contractor's bill was about 2 crore 83 lakhs. There
Then what is
1%
wrong?
was deducted.
Yes, what is wrong?
That wrong because this is not applicable in respect of the petitioner who is not a registered contractor. Unless we are, and this is not a contract work also. We have just cleared the desilting from the agricultural field. This
I
is
used
not a-
therefore submitting that this is a case of service, not on that.
Yes,
Nothing to of
that's right.
any
Yes,
sale.
maybe. You correctly put it.
Mr. Das, I think you
Your lordship
have
has
to
put it.
develop your argument in that
But-
manner only. That
Your
it
lordship
is a
has put it
service, not a
correctly.
sale. And as such, it would not come within the ambit of a works contract. You have to
So
develop your
yes,
argument on
your
that,
lordship is correct, and I think I stand corrected.
but not on this basis. This
No,
composition scheme, I think you need to prepare yourself properly.
No, this notification was given by them only.
No, they may say many things, but the
And but
question
AG's
is, Mr. Das, you have to.
AG's affidavit is very clear. And same question was raised by your lordship in the order dated, my lord, I'll just point out.
I raised,
Not your lordship, Justice Budhabudwa,
if
12/9/2018,
I have raised immediately, I would have dismissed it by now.
12/9/18. Your lordship will allow this.
12/9/18.
18.
If you are not a
Just-
registered contractor, there is a further fine. What you are submitting will have a.
Question, my lord, your lordship has raised a question.
Where?
Same question has been raised, last paragraph. Order dated
Whereby
12/9/18.
works executed by petitioner were treated to be works contract on Neyman. is
What was the sale
to
component?
enable the respective council to obtain necessary Neyman. In time order passes the name for Neyman.
Last paragraph, my
So
lord.
they are therefore saying that this is a works contract and as such you are liable to pay.
This is not works contract. There is no sale component in it. We have not sold anything.
No, you don't need to sell it.
Yes,
A works contract is a different, it is by virtue of the amendment to the constitution, works contract have been brought within the ambit of sales.
my lord, your lordship will kindly see the VAT Act. VAT Act,
Huh,
this is applicable only in respect of sales of goods.
huh,
256(2).
huh.
Section 256.
Hmm.
Means a tax on sale of any goods at every point in the series sales made by the registered dealer with the which is the provision? Section 256. Tax on sale.
Mr.
Of
Mr.
any-
Das, kindly come to page, section 243.
Yes.
Two 43(2),
Sale.
a transfer of property in goods, whether as goods or in some other form involved in the works contract. Delivery of goods on hire purchase, transfer of right to user, this is for lease. Then transfer otherwise than in pursuance to a contract so and so, therefore payment. So here you come under 2.
My lord, your lordship will
So
kindly see
you
the
are to
notice.
therefore submit. I think I'll give you time for that. You have to prepare yourself on this basis that it is not a service, it is here. Recently, you find out the judgment of Justice Oka. I think Justice Oka's judgment, recent judgment is there. Find it out, isn't it?
Look.
He will help you out.
Lordship, I'll just take a look.
Give that judgment. Because he has dealt with many other various judgments and all, and then have recently come. This is of 2024 last or 2025 beginning.
Justice Oka.
Justice Oka and Justice Bhuya, I suppose.
That's
On transfer of property.
That's
And this is on the question of lease. That was a case of lease. But this is a case of works contract.
it.
That was a case, I think, was of lease. I think you have to get it because you have to look into various judgments from Gannon Dunkerley and all these judgments have to be looked into as to whether this will come within the ambit of service or sale. Because service, there is nothing. But have you paid any service tax?
1% tax was taken, only.
No,
service.
1% is a different thing. Whether you have entered, you will say that you are not registered. So there is no.
Your Lordship looks into page 19.
No, if you are not registered, you cannot be, the question of composition does not arise. So you have to therefore show that it is a service. And if it is service, then prior to GST coming, they are out. But if the moment it says that it is a works contract, then you have to pay.
My lord, your lordship can kindly see page 19. The lordship can help me more one. He invited from the owners of the tractors registered under so and so for desiltation.
Yes, desiltation is a work.
This work.
Whether
Why-
it is a service, we have therefore come up. Whether it is comes within service. If it is a service, then it comes under the Finance Act
Yes.
in 1994. If it is not, then only they can impose. But if it is a service, then there cannot be a works contract. Look into those judgments. Okay. When do you want? And why is it mentioned that this is for levy on bill amount of the petitioner? Does not appear to be a matter covered by bench 2. Okay. Okay. Okay, when do you want it? To finish it off?
2 weeks.
But you have to get ready
I'll
with
get
these properly. Okay, list this matter again on 2 weeks. I don't have time. Anyways, list this matter again on 9th of September 2025 at 2 p.m. An attempt shall be made to dispose of the petition on that date.
That's my concern.
Apply.
Supreme Court has directed to include all future tenders.
So these have to be incorporated.
This has to be incorporated as per Supreme Court. Maybe due to that reason,
My lord, my case, my lord, the first tender and second tender similar, my lord, nothing is included.
No, now they have to recall that in fact.
My lord, the second tender issued 22nd, my lord, last date is 88, my lord. The similar thing, first date, first NIT and second NIT, my lord, kindly see page 18, vernacular part and 27, my lord.
No.
Same. Nothing be incorporate, my lord. If the second NIT, my lord, incorporate this thing, that is the, with this, the covered by the judgment. my lord. But there nothing, my lord, as it is, my lord. First NIT and second NIT, my lord.
first 15 days.
All the column are similar, my lord. First tenant and second tenant. If they report the third tenant, it will be approved.
You submitted the first tender.
Yes, my lord.
Then
Then, my lord, I submit first tender, my lord, and as per information, I am the high bidder. I approach the authority to settle me being a high bidder, my lord. But subsequently, they issued second 1080, my lord.
second NIT, does it contain those clauses?
Some things, my lord. Page 27, my lord. Nothing else, my lord. Every word is same, my lord. This is new. This is new. This is not been recalled. This is new. 27. This is new, my lord. Page
The
27.
new tender, have they incorporated those terms?
No, lordship.
Nothing, my lord.
This is not being incorporated.
Because this tender also has to go.
Yes, lordship. Yes, we, actually, this tender also has to go as per the Supreme Court order, Honorable Supreme Court order.
Now, in view of this office order,
Lordship.
both the tenders have to go.
Yes, yes.
Then, yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. P. Sharma, the learned counsel appearing on behalf of the Fishery Department of the Government of Assam. That is the respondent numbers 1, 3, and 4. 1 and 4. Mr. So-and-so appears on behalf of the respondent number 2 and 3. The petitioner herein is aggrieved by the action on the part of the respondent authorities in calling for a fresh tender on 22/7/2025 to the respondent number 2. It is the case of the petitioner that the petitioner participated in the tender process initiated by NIT dated 4/6/2025. The petitioner had reasons to believe that the petitioner was the highest bidder and was expecting that the mohol in question, the fishery in question, could be settled with the petitioner. However, the respondent number 2 have issued the fresh tender dated 22/7/2025, issued by the deputy respondent number 2 had issued a fresh tender dated 22/7/2025 in respect to the same fishery. When the matter was taken up at the stage of motion, Mr. P. Sharma, appearing on behalf of the Fisheries Department, places before this court an office order dated 10/7/2025, issued by the Secretary to the Government of Assam Fishery Department, wherein it has been mentioned categorically that the directions so passed by the Supreme Court in the case of MS Teteliguri Navajuti Matsyajibi SS Limited versus State of Assam and others dated 21/5/2025, wherein it has been duly mentioned that the directions passed by the Supreme Court in the case of so and so dated so and so has to be adhered to, and any omission or lapse in complying with the said directions, the NIT in question would be invalid. The relevant portion of the said office order, the contents of the said office order is reproduced hereunder. It is seen from the above quoted contents that the Supreme Court made it clear in the case of MS Teteliguri, Supra, that all tendering authorities, in tender inviting authorities must incorporate a specific clause in the notice inviting tender stating that the documents and procedure laid down in the government circular dated 18/1/2018 shall be mandatorily followed so long as the circular remains in force. And a copy of the said circular is also required to be enclosed to the NIT. This court had duly taken note of the NIT dated 4/6/2025, as well as the subsequent NIT dated 22/7/2025. However, it is seen that both the NITs are contrary to the directions passed by the Supreme Court in the order dated 21/5/2025, passed in so and so, Supra. Considering the above, this court therefore considering the above, both the NITs dated 4/6/2025 as well as 22/7/2025 are contrary to the directions passed by the government of Assam Fishery Department in the office order dated 10/7/2025, which is quoted here in above. Therefore, both the NITs cannot be sustained in law and accordingly set aside, liberty given to the Fishery Department as well as the respondents to initiate a fresh tender process by following the mandate of the office order dated 10/7/2025, and more particularly the directions passed by the Supreme Court in the case of so and so Supra.
Highly obliged, Lordship.
Item 8.
Yes, where is Mr. B. Gogoi?
Actually, we still on Lakefront Court number 1. Actually, there's an appeal matter. Actually, there's an appeal matter going on over there. That's why.
Well, we stayed then. Let him be there.
Lordship,
In the-
kindly give me some time. Kindly some time, Lordship.
I've only asked them to obtain instruction. This is
But-
by an authority which has no jurisdiction.
Most likely, Lordship, he has.
Issue notice making it returnable on 22nd of August 2025. Pustak. Issue notice now. We dismiss it. We set aside that.
Lordship may not pass that order. Lordship,
I've
give me
passed
some
on the
time.
order. I've said it at 2.
Lordship, he might have some instructions. He might have some instructions regarding this particular matter, Lordship. That is
He
why
is
I'm
not
paying for some
here.
time.
I gave him the opportunity. We
He's
set
on-
aside these 2. Because it is done by an authority who has no jurisdiction. That's all. Giving you liberty to take steps as per law.
The only thing is, Bharat, if it is done without an opportunity, they might take that point in appeal again. Take it up in appeal and take that point. That no opportunity was given.
He's there now.
Lordship, but I'm not privy to those instructions, Lord. That's why I'm praying, Lordship.
You're not
Kindly
privy, I can't help you. Officer is there. That he's the
Otherwise, it is expressly without jurisdiction.
expects me without jurisdiction. So what is there? Set aside that. I gave you the opportunity there too. Because staying it makes no sense. How do I stay? Because if I stay that order,
Lordship,
I can't stay at terminated order.
Lordship.
I can only stay at tender process. Tender process is there. We stay the tender process. Issue notice making it returnable on 22/8/2025. Mr. So-and-so, look. Mr. Enrique accepts notice on behalf of the respondent number one. Mr. Bigoy accepts notice on behalf of the respondent number 2 to 5. As all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The petitioner herein was the case of the petitioner herein is that he was that the respondent authorities had allotted a work for construction of Sri Aniruddha Deva Sports University at Sabua, Assam. By the work order dated 30/11/2023. At a contract price of rupees 56,62,50,960. The period of completion of the contract in question was 24 months. A contract agreement was also entered into by and between the petitioner and the respondent authorities. It is the case of the petitioner that the petitioner was performing the work all of a sudden a final notice for determining the contract was issued by the executive engineer PWD on 29/5/2025. On the immediately on the next day, the executive engineer PWD terminated the contract by the communication dated 30/5/2025, which have been challenged in the instant proceedings. The learned counsel appearing on behalf of the petitioner, senior counsel appearing on behalf of the petitioner, submitted that though there is an arbitration clause, but the manner in which the termination has been done apparently is in violation of Article 14 of the Constitution, as the same is arbitrary, illegal, unreasonable, as well as palpably erroneous and without jurisdiction. In support of the submissions, the learned senior counsel drew the attention of this court to clause
Page 328, clause 3.
3.
Page 328. Clause 3.
Clause 3 of the
Contract agreement.
contract agreement of the conditions of the contract which stipulates as to when a contract can be determined. The learned senior counsel, drawing the attention of to the said clause, submitted that the power to determine is conferred upon the engineer in charge. The learned senior counsel further, drawing the attention of this court to the definitions contained in the conditions of the contract, and more particularly to clause 2, Roman 6 and 2, Roman 7, submitted that the engineer in charge means the engineer who shall be in charge of the work, means the chief engineer who shall be in charge of the work, and who shall sign the contract.
Sorry to interrupt, my lord. I've got the instruction, my lord. Lordship will give us the liberty, we are going to withdraw this. But that liberty to issue afresh through the proper authority, that may be given, my lord, if so advised. So far as that impugn. I've got the instruction.
Engineer in charge means the chief engineer who shall be in charge of the work and who shall sign the contract on behalf of the governor of Assam, as mentioned in Schedule F. It is further seen that the terms chief engineer have been further explained to mean the chief engineer PWD building Assam. The learned counsel standing counsel appearing on behalf of the PWD submits that taking into account the clause 2, Roman 6 and Roman 7, 2 Roman 6 and 2 Roman 7 of the conditions of the contract, and read with clause 3, the 2 Roman 6 and Roman 7, 2 Roman 7, as well as clause 3 of the conditions of the contract, it appears that the termination of the contract by the executive engineer do not appear to be in consonance with the terms of the contract. He, however, submitted that taking into account that the period that there is a time, that time is the essence of the contract, and the period of completion was 2 years, and the progress being not sufficient, the respondents have rightly terminated the contract, have rightly determined the contract. This court has given an anxious consideration to the respective submissions. As it appears from clause 2, Roman 6 and 2 Roman 7, read with clause 3 of the conditions of the contract, it is the chief engineer, PWD building Assam, who has the power to determine the contract. And therefore, in the opinion of this court, the action on the part of the executive engineer, who is the respondent number
5.
5. That is the respondent number 5. To determine the contract by the impugned communication dated 30/5/2025 is palpably erroneous and without jurisdiction. This court, therefore, without going into the question as to whether the respondent authorities were justified in terminating the contract or not, sets aside the order dated communication dated 30/5/2025, whereby the contract between the petitioner and the respondent PWD was determined. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, the communication dated 30/5/2025 issued by the executive engineer PWD, Dibrugarh, Sabua, Lahual, Kuang, Tingkong Territorial Building Division, Dibrugarh. That is the respondent number 5 is set aside and quashed. Number 2, this court have not entered into the aspect as to whether the respondents is justified in terminating the contract or not.
Right.
Number 3, liberty given to the respondents to take action if so advised as per the mandate of the contract agreement. About the issue notice heard so and so, so and so, and so and so. The instant writ petition is taken up for the disposal at the motion stage.
So far as the NIT is concerned, if they proceed, otherwise my rights will be.
Number 4, the
NIT is dated 20th of July.
Where is that NIT?
409. They have issued the press notice, but nothing is uploaded in the website. So I don't think anything has been done.
This is the NIT.
This is the press notice. Pursuant to that, they are supposed to upload the tender documents, which on the Assam tender portal, which has not been done.
It may be made subject to the fresh decision taken by the authority. If they want to retain the petitioner, they will, otherwise this will go. If they again issues a notice and takes a decision against the petitioner, if at all, then
you issue a press notice if you take a decision, thereafter you do it. Number 4. The press notice issued for inviting a fresh tender is interfered with, taking into account that this court had interfered with the communication dated 30/5/2025 issued by the respondent number 5.
Right.
Liberty which I have given is to take an action as per the contract. Okay.
Item 41.
Yes, Mr. B. Gogoi. This is that matter.
Yes.
Tender below 50%, 20 lakhs and 19 lakhs. That
Yes,
day,
yes.
you remember?
Yes,
The
ma'am.
last
That's
night
OM,
of
my
the
lord.
day
Yes.
I was taking it up.
Yes, ma'am.
So here is a case where he has he aggrieved by the 19 lakhs tender, which is
Lordship.
again being floated. Where is that irrigation? No irrigation department person. Is it permissible? Here the finance is there, na?
Finance is not a party.
Okay, you appear as the
Yes,
counsel
yes.
for the district commissioner, additional AG. Now tell me, whether, because the decision was taken on the last occasion.
My lord. I will place the provision of the.
An e-tender, that is what I was
Yes,
mentioned.
ma'am.
You referred to 2 documents. One was 22-1, I suppose,
Yes.
and the other is 8-1. Now they are.
1/24 of 2022, another.
This court held that the 8-1 is not proper, taking into account that it has not been gazetted
Gazette-
notified.
Yes.
Yes.
So 22 remains otherwise, madam.
So as
There also-
22, what is that?
My lord, there also it is stated that, my lord, all tenders will have to be through GEM portal. It is mentioned, my lord, in 22.
Where is your person concerned?
In fact, my lord, in the course record, probably those OMs will be there.
They have removed it. Oh, actually, oh, yes, I've got that. No. Yes, I've got it. This is 8-1, 8-6. Purchases valued above 5 lakhs are to be compulsorily made using online or reverse. This is for
No, there is a guideline, my lord.
for the SOP of 8-1-2022.
Yes, that gazette notification of 22 was also there. my lord.
28-1-2022.
Yes.
Government e-market is mandatory for procuring entities for procurement of all goods and services that are available in the GM except cases. And the procurement intends so and so nomination of the nodal officer. Here it does not say anything. Does it say anything? This notification of 28-1-2022.
At the very heading, my lord,
In pursuance to Rule 22-1 Iman and others, the power vested in the Finance Department on their, it is directed that government e-market GM is mandatory for all procuring entities for the procurement of all goods and services that are available in GM, except in cases all emergency procurement and urgent works as defined in the Assam Assam Procurement Act and the Assam Procurement Rules. Procurement intends statutory autonomous visit, there's Morang, so and so, all this autonomous is outside. Procurement done through spot purchase and request for quotation. Any item to be notified by the department will due concurrence of the finance department. So this has to go for month. And what is the amount which goes for that?
amount perhaps is not there in the act, my lord, but that provision is there, my lord, that it will have to be notified.
This short tender notice is also a system which I think it's high time you should close this.
Not sure.
This is a very dangerous thing.
Not sure.
Fairness is thrown to the wind. Short tender. Huh?
Yes.
Your case is short tender.
Yes, right. Yes.
Oh.
Short tender.
Short tenders are not properly published. It is only known to Mr. Sahu and one or two, isn't it? How many participants?
My lord.
How many participants in
Uh,
pursuance to the tender?
Uh,
Must be two only. You and another.
maybe
Because nobody else knows, na? Short tender is that is the benefit of a short.
Yes.
Now, what is this tender? Have you looked into? Let's see.
Page 23, my lord, that the MIT is doing.
Boring installation of tube well. Final survey construction of approach road. Boring installation of so and so. Final survey of so and so. Now they have gone for they have only cancelled it.
Yes, sir.
And in view of the cancellation of the said and the work order it should be used and nullified. Now, in this case of Ranjit Tamuli,
Ranjit Borua. My lord.
Ranjit Borua. But tell me, here it has been held that this is to be notified by in the official gazette.
My lord.
But how do you get that aspect of official gazette?
That notification has been defined, my lord, in the definition column, my lord, of the, my lord, act. Notification means gazette notification. That is
Notification published in the email. But how do you incorporate this shall notify
my lord, that
the detailed guidelines for such online procurement through GM together with the mode and procedure for making payment to the registered supplier and may also prescribe financial sealing or any other. But even as per the notification of January 2024, if it is less than 20 lakhs, it is not necessary.
No, it says, my lord, the procurement of goods and service valued less than INR to 20 lakhs may also be procured through Assam tender portals at the discretion of the entity within, my lord, bracket, if and only if the goods and services are not available in JAM. It will, if the goods are not registered in JAM, in that case, my lord, they can go for this option.
Now you see that procurement of works B, next kindly come.
My lord.
Works valued above 20 lakhs shall be procured through Assam tender portal. Works valued less may also. You see, the difference is shall and may.
Yes, may.
So therefore, it is absolutely within the discretion of them.
But my lord, if and only if the goods and services are not available.
Kindly come to the next page, D.
B, yes, ma'am.
So below 20 lakhs, may.
No,
It is
B,
the
my lord, it says about for procurement of works.
Here is
It
the
is work,
portion of
here it
work.
is work, yes.
So
Works
works
valued above-
valued less than they may also be. So it is the discretion. Yes, what is wrong with you?
Lordship, I'm sorry, I'm late, Lordship, I'm sorry.
Yes. Well, what is your instruction? Why are you going for online bid?
Okay, please, Lordship.
No.
Lordship, may kindly see the work order, Lordship, page 23.
There is notice inviting tender.
Lordship, yes. The notice inviting tender, Lordship, it is showed, Lordship, the works were after breaking the work, Lordship, the notice was issued, Lordship. So that, Lordship, it comes below the 20 lakhs. And so that is why the chief engineer has, Lordship, directed the executive engineer to.
Means you say that the action which have been taken by this executive engineer was wrong because of the fact that our work, which is a composite work, have been bifurcated to do away with
Yes,
the
Lord.
online bid.
Yes, Lordship. Yes.
Hello, put it on affidavit.
Lordship. Lordship.
Yep, it has been cancelled. No?
Will not cancel.
Put it on affidavit that.
Lordship.
Issue notice making it returnable on 8th of September 2025. Mr.
N. Upadhyay.
And Upadhyay appears and accepts notice on behalf of the respondent numbers 1, 2, and 4. Mr. B. Gogoi, you appear in the Mr. B. Gogoi, the learned additional advocate general, accepts notice on behalf of the respondent number 3. It is pertinent to take note of that extra copies of the petition be served upon upon the learned counsel by 6/8/2025. The case of the petitioner herein is that pursuant to a notice inviting short tender, dated, what is the date? No date.
No date, Lordship.
No date.
That was there, my lord.
Nobody knows.
Page 23, there is no date.
No. Notice inviting tender, comma. The petitioner issued by the executive engineer Dharmapur, Borkhetri, Nalbari Division Irrigation. The petitioner was awarded the contract for boring and installation of tubewell and installation and commissioning solar PV modules, including mounting structure at construction of 1 number solar powered MDTW schemed at 2 number Ghorathal village under SOPD-SC SP for the year 2023-24 on 1/8/2024. এইটো আপুনি ডিটেইল বস্তুটো ইয়াত পাই যাব হা পেজ 26 serial number 1 পাই যাব হা. It is the case of the petitioner that although the contract agreement was entered into, but the site was not delivered to the petitioner on account of certain complaints. However, all of a sudden, on 25/6/2025, the executive engineer Borkhetri Nalbari Division, that is the respondent number 4, had issued the cancellation order And further, have issued the cancellation order, which has been impugned in the instant proceedings. Have issued 2 cancellation orders, huh?
Yes.
Have issued 2 cancellation orders in respect to the 2 works, 2 contracts, which was awarded to the petitioner.
Here number 1 and 3.
1 and 3 this is, huh? Page 23, huh? 1 and 3. A notice inviting tender dated 14/6/2024. The petitioner is aggrieved by the action on the part of the respondent authorities to cancel the said tender, said contract, that too without providing any opportunity of hearing. Mr. Enukaida, learned counsel appearing on behalf of the Irrigation Department submits upon instructions that the reason for which the contract entered into between the petitioner and the respondent department was cancelled was on account of a composite contract was bifurcated into 4 divisions by the executive engineer, that is the respondent number 4, so that the requirement of online bidding is dispensed with. The learned counsels therefore submitted that from the very notice inviting short tender, it would be seen that all these amounts, all the 4 contracts were purposefully made below 20 lakhs, so that there is no requirement to follow the mandate of online bidding in terms with the Assam Public Procurement Rules 2020 and the notification issued in connection therewith. Taking into account the overall stance by the parties, this court directs the Irrigation Department to bring on record their stand by filing their affidavit on or before, when did I fix it?
8/9.
On or before 1st of September 2025. Mr. B. Gogoi, the learned additional advocate general who appears on behalf of the respondent number 5, respondent number 3, is also the standing counsel for the finance department. This court would direct the finance department to bring on record their stand as to such a course of action is permissible of bifurcating a composite contract in order to dispense with the online bidding.
Till then,
What? Terminated contract, you die, then I will make you alive. I have Mitra Sanjavini. No, I don't have. That only you have to go to that hill. There's a hill which Hanuman brought, na? You get there.
In
Then I can give it.
similar repetition, my lord, that
Nothing is going to happen. They also know.
Item 43.
The matter relates to suspension of a fair price license. Now, on several date, my lord, an issue cropped up as to when was this notice served. If your lordship kindly goes to the order sheet of the case, my lord.
Mr.
27
Chaudhary, did you submit your so-called reply?
My lord.
Have you submitted your
No,
so-called reply?
No, that we'll come to that. So reply file correction. Yes, I have done it
During the pendency.
during the pendency of this case.
Okay, let them take the decision.
No, my lord, I am on a different plank altogether. Clause 15(2), my lord, creates a legal fiction. If within 90 days so-called notice is not given, then my lord, it will automatically stand vacated. That is the issue. Now they have shown that by substituted service, it was done. If your lordship would kindly see the order sheet on 27/1/25, 17/2/25, 5/3/25, 13/3/25, 19/3/25, 27/3/25, 2/4/25 and 10/4/25, government advocate was directed to produce materials to records to show that notices were served. And in the first affidavit, they don't take this stand. It is only pursuant to this honorable court's order that they have come up with that plea, my lord. And my lord, coincidentally, 22nd was a holiday. I do not know how government offices functions on a holiday, my lord. I can understand if flood relief is to be given, one can give it. But normal functioning, does it take place? At page 17, my lord, that clause order 15 is quoted. No order of cancellation shall be made under this clause unless the license has been given, licensee has been given a reasonable opportunity of stating his case against the proposed cancellation by an order. But during pendency or in contemplation of the proceedings of cancellation of the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case. Now they would like to say that the show cause notice was served on 21/7/23. Dated and on 22/7. In fact, my lord, in the first affidavit which was filed by them, nowhere they mentions of the substituted service.
When were you suspended?
10th July. 10th of July, my lord. Suspension order is dated 10/7/23 at page 39.
Now, have you submitted a reply to the show?
Yes, subsequently we have done it.
When did you do? And what is the order that no coercive measures should be taken? Why the interim order is there?
No, my lord, pursuant to the show cause notice that they will not take any coercive measure, that order will be.
But wouldn't that be interfering with the jurisdiction? They have a right to do.
No, my
If
lord,
you agree,
regarding
we can very well.
regarding taking the show cause notice to a logical end, that is not our challenge. Our only challenge is, my lord, since we have not served the show cause notice within 90 days, the suspension order ceases to have a need. Our case is only limited to that extent. We are not contesting the stand of the government that there is some allegation that they would like to inquire into it.
When
Those
did you
are there.
submit the reply?
My reply to the-
Show cause reply.
127, Miller. There is a affidavit in reply by the petitioner. at page 127. In fact, subsequently, my lord, on 27/11/24, another notice was issued. Then we came to know that on 21/7/23, there was a notice. They didn't.
Now, who is appearing for the respondent? What decision have you taken pursuant to the show cause reply?
My lord, pursuant to show cause never, because there was their order, my lord, not to take.
And not to coursive action, but have you taken a decision?
I think, my lord, they have not taken any decision, my lord. I have to take instruction, my lord, because they, regard I have.
You know, this matter has been taken up. This is the third date I have taken it up. What is wrong? The allegation which you have made is a serious allegation
Yes.
of misappropriation and all. The question is, you have not given it within a particular time. That is his case, that it should, the suspension should go. But be that as it may, the question is, when there is a show cause notice, which he has received and he has submitted a reply, as you could have seen on, yeah, what is the date of your reply?
One second. It has received.
No date.
My lord, it will be sometimes in December.
No date given.
No date. After 20, it will be sometimes in first week of December.
Where is the receipt?
First week of December.
Lord, a precise date I cannot give. But we have submitted, my lord.
There is no date mentioned
Not
again
mentioned,
here
my lord.
also.
There is no endorsement also, my lord, that it was issued.
No, you have not disputed this. This affidavit was filed long back. Well, there is no dispute that you have filed it. Because this affidavit was filed on
21/2025.
Therefore, it has to be prior to that.
I will take instruction on what they have done on this, my lord. After filing this, my lord, reply, my lord.
Tomorrow, 2 o'clock.
Tomorrow.
Or ask your additional deputy commissioner to be present. Video. Ask him to be present.
Yes, first I will take instruction.
Now, first of all of you keep on changing. Earlier, when the matter was taken up, Miss Yudas appeared. Next date, nobody appeared. Today, you are appearing. And you don't know anything. Earlier, Miss Yudas submits another aspect of the matter.
Regarding my lord,
We have tried to serve him, but
Yes,
he
ma'am.
was
That-
not there.
that is
You were
there,
asked to produce the records. Why the records have not yet been produced? Whether there was no direction for production of the records.
Yes, there are so many dates there. I read out those dates, my lord, only for production of the records.
Where
Then
is-
they came up with this novel idea of substituted service.
Where is this? Borpeta.
Borbeta.
Let's see the records.
Yes, ma'am.
We'll have it on Thursday, 2 p.m. Get the records. Either get the records or ask the additional deputy commissioner to be present.
I didn't know.
Either of it. And give me an instruction.
आज तो Monday है.
The heard Mr. K. Chaudhary, the learned senior counsel, assisted by Mr. A.K. Azad, the learned counsel appearing on behalf of the petitioner. Mr.
M. Setia, ma'am.
M. Setia appears on behalf of the government of Assam. Who are you? Cooperative Department. Mr. V. Rashka appears on behalf of the Corporation Department of the government of Assam. The petitioner herein have question the continuation of the suspension order dated 10/7/2023 beyond the period of 90 days in view of clause 15(2) of the Assam Public Distribution of Articles Order 1982. Read with the Control Order of 2015. It is the specific case of the petitioner that on 27/11/2024, a notice was issued, and in pursuance thereto, wherein the copy of the show cause notice dated 21/7/2023 was enclosed. It is the further case of the petitioner that in pursuance to the said show cause notice, a show cause reply have been filed. There's no date mentioned in the show cause reply or even in the contents of the affidavit in reply. Be that as it may, the affidavit in reply is dated 21/2025, which presupposes that the show cause reply was filed prior to 21/2025. This court inquired with the learned counsel, standing government advocate, appearing on behalf of the Deputy Commissioner, District Commissioner, Borpeta, as to what decision has been taken in pursuance to the show cause reply. The learned counsel submits that he would obtain instructions in that regard. This court further takes note of that there are various orders being passed from time to time directing production of the records. It is surprising to take note of that in spite of such directions being passed, the records have not been produced pertaining to the suspension and the issuance of the show cause notice upon the petitioner. Considering the above, this court fixes this matter again on 7th of August 2025 at 2 p.m. The records be produced without fail by the additional
Deputy Commissioner.
Deputy Commissioner, Borpeta, Pusto. It is observed that if no records is produced, the additional Deputy Commissioner, Borpeta, shall be present through the video conferencing link to be provided by Mr. M. Setia at 3 p.m. on 7/8/2025. Interim order passed earlier shall continue till the date. But Mr. Chaudhary, I am not going to do that, interfere, but they have to be taught a lesson. But yes, it's other thing. Yes, now submit.
Would I said the parties to release me from
You
that?
are still appearing in this matter?
They have not, they are saying that you argue the case, whatever. Now, if you want to accept the matter, then I'll argue.
Yes, I'm taking up because the Chief Justice said no action is required.
Yes. No, I have.
Big and
that
bold
is
letters.
After his discussion and your discussion.
Yes.
Now, here, my lord, I am giving a short story of the case. One late Ganesh Datta filed a title suit against the present civil petitioner that he has been occupying my land, and that land I have purchased from Nasim Ali Hazarika. Now, Nasim Ali Hazarika was not shown as the witness. And Nasimari Hazarika's name was also struck off in a suspicious manner. The learned trial court framed as many as kindly see 23 eight issues were framed, page 23. The main issue was that issue number 6, whether the defendants have been adversely possessing the suit land after constructing the dwelling houses thereon. It is decided in our favor. Whether the defendants, 5 is defendants were permissive possessors of the suit land, it is decided against the plaintiff. That means we are not permissive possessor. And whether the plaintiff is entitled to a decree, it is negative. No, he is not entitled for any decree because his sale deed is found not genuine, it is disapproved. So, when he filed the case,
So his suit was dismissed.
Suits were dismissed.
Then the plaintiff filed an appeal.
No, let me submit. Kindly bear with me because case is a long journey. The case is.
No,
Right.
Mr. Mahmood, Mr. Mahmood.
Now-
Mr. Mahmood, wait. First and foremost, the suit was filed by the plaintiff. The plaintiff's suit was dismissed.
Dismissed.
Okay. The plaintiff filed an appeal. Appeal was dismissed.
Dismissed.
Then you filed an execution application.
Yes, the party filed an execution petition.
The defendant filed an execution application saying that he becomes the decree holder
Yes.
and sought for execution.
Yes.
A writ for delivery of possession was issued,
Yes.
and accordingly possession was handed over to you.
Possession one lesser land. One lesser land.
One
lesser land.
One lesser.
And but
Sir,
that
I'm not
was
concerned. But possession was handed over to you in pursuance to a suit which had been dismissed.
Let me clarify this matter. From one lesser land, one Hussain Ahmed Chaudhary was evicted, not Ganesh Chandra Datta. Now, when the court says the sale deed is not proved, that means Ganesh Chandra Datta has no land there at all. This should be clear. And my learned friend Manus cannot prove that anywhere, everywhere, every court is saying that this sale deed is disapproved, not proved. So, Ganesh Chandra Datta has no land at all. But here, when it was the Seshadar and other persons went there, one person was occupying one lesser of land, that is Hussain Ahmed Chaudhary. That Hussain Ahmed Chaudhary was evicted. I understand that. I understand Lordship's anxiety that when there is no decree, that is the main and pertinent question. The question is this: Supreme Court, my Lord Justice Arijit Prasad said, the law is the last order passed by the last judge. Law is the last order passed by the last judge. The first appellate court prepared the decree. So that is the last court, because after that order of the first appellate court was not challenged. So,
what was the decree prepared?
That decree I have annexed here.
The appeal is dismissed.
Yes, that is the decree.
But how?
Dismissal is also a decree.
Proceedings.
No, my Lord, I am submitting. Now, Hussain Ahmed Chaudhary was dispossessed, evicted. Ganesh Datta has no right at all, because in every court, he has lost the case. In one case, it was remanded, but on remand also, that was dismissed. So, there is no land of Ganesh Datta. Now, before your Lordship, Ganesh Datta is here, but he has no land. The evicted person is Hussain Ahmed Chaudhary. He is not here. He is not here. But now your Lordship is on administrative side, whether, perhaps subject to correction, that whether the court, when there is no decree,
I am on a supervisory side, not
supervisory side, yes.
Yes.
Now, your lordship is on that supervisory side that when there is no decree, so how the court proceeded with the title acquisition proceeding? Well, that is your officer. What can I do? What can I do? But
So
things-
therefore, when his case is there for restitution,
who will get the restitution?
he has filed the proceedings for restitution. That is his case.
How he can get who? Here,
Mr. Mahmood, whether he has a right to continue with that proceedings or not, it is for the executing court to decide. I'm not going to decide on that aspect, but the executing court has to decide as to whether the petitioner therein or the respondent herein was dispossessed in pursuance to a decree, pursuant to an execution proceeding which was non-est.
No,
that is the
the report is here. Lower court record has come.
I've seen it.
And here it is, Hussain Ahmad Chaudhary is evicted. And one lesser of land. Not the respondent.
No, that is a question which they will look into, the executing court. The executing court will look into as to whether the petitioner, the respondent herein, was evicted or not. But there could not have been done at the behest of the court. You evict them, it's a different thing. Outside the court, you can do many things. I'm not on that. But if you take the help of the court cannot aid an execution proceedings in absence of a decree.
Yes, the court should not have accepted the title execution.
Absolutely.
That I understand.
Has happened,
but my
the
lord,
court is required to do the needful. That's all.
But my lord, kindly appreciate this point that the person who has been evicted, rightly or wrongly, he is not there.
Mr. Mahmood, this is a question which can be decided by the executing court. What you are doing out here is this. The proceedings being miss case number 2 of 2015 is being stalled out here. That is to be decided by the executing court. Let it be done by the executing court.
And my lord, here, another thing, whether there will be the conflict of judgment between the...
Don't worry.
Because...
I will take care of that.
My lord Justice Shoikia has clearly stated that when the other party, that means present respondent, has said that we will not adduce any evidence, case should be closed there. That is there. Kindly see page 117.
Yes.
It is 117 bottom. It is cardinal principle of law of evidence that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts, which he asserts must prove that those facts exist. The burden of proving those facts lies upon him. Section 101 of Indian Evidence Act. In the case of Vidyadhar,
Mr. Mahmood,
so many
petitioners therein were you. You were the petitioners in that proceedings.
Yes, I was the petitioner.
You said that you are not going to adduce any evidence.
No. They say. No. My lord is not correct.
Here you kindly see paragraph page 108.
They say we will not adduce any evidence.
When the petitioner refused to abuse evidence as a witness for proving the fact alleged in his petition, naturally the court will have no hesitation to hold that the allegations raised in the petition are not true.
No, kindly see page 98.
Proceeding further with the matter by wasting judicial, the impugn order dated so and so passed by the municipal is set aside.
Page 98 kindly see. That is their petition. That is not our petition. We have not said this. Kindly see. Page 98. Ranjan Datta, that is Ganesh Datta's son. The lawyer for the petitioner. Here petitioner, mid-J case number 2, petitioner is Ranjan Datta. That is the son of late Ganesh Chandra Datta. So the lawyer of the petitioner is present in the court today that the substitute petitioner do not want to adduce their witness. That their petition is filed bona fide. It is therefore most humbly prayed that the learned court would be pleased to allow the petitioner to close their personal evidence and further be pleased to allow the petitioner to take the seat of the official witness. So, my lord, they have filed this mid-J too, and they said that we will not adduce any witness. That is why court said that when you are avoiding adducing any evidence, official witnesses, how they can prove? How
Why?
they can prove?
Why?
Because that is the land in the name of none. As per High Court's order, as well as lower court's order, they have High Court, lower court, both the courts will have said that they have acquired at
No.
of 80 years.
No, Mr. Mahmood, those are not the questions which are there. It is not the question whether Ganesh Datta has or his son has title over the land. That is not the question there. The question before the court was simple as to whether without a decree on the basis of an execution proceedings, a person have been evicted or not. That is the question. And this could be only proved by the official witnesses who were there, who were the person, whether that person concerned who you say Hussein Ali, he was there or not, or whether these petitioners were there. This is to be proved by the Nazir. This is to be proved by the persons who went out there for the purpose of execution. This is the question which is there.
Now,
Whether they give evidence or not, that Mr. Mahmood, whether they give evidence or not, that the court will look into it. I am not on that. But a question of this court interfering at your behest does not arise. Okay,
but
now
the thing is,
heard Mr. M.U. Mahmood, the learned counsel appearing.
my lord, one last, my submission. Every finding is in our favor, and what they prayed, that is always against them. And the evicted person is Hussain Ahmad Chaudhary. He is not here. And they filed petition mid-J case number 2, but they say we will not adduce any evidence. So all these things may kindly be recorded.
I'm mentioning it.
And so far the initiation of title acquisition proceeding, well, party does not know the law. The officers, judicial officers know better. Now
for that, I'm taking up action against the judicial.
yes,
Don't worry.
that is your lordship discretion. I have nothing.
No,
But
that I'm going to do it. That
but
is why
my interest should not be suffered.
no, this is a very serious thing which the judicial officer has done. If he has
Serious
done.
thing.
So for that,
definitely,
I'll be
judicial.
asking the High Court on the administrative side to take action against.
But by doing that,
By this order, I wanted the name.
We are
Anyways,
in a-
let me dictate. Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, and Mr. A.K. Sahewala, the learned counsel appearing on behalf of the respondents. The 26/4/6/2025 order 2, paragraph 2, paragraph 3, paragraph 4, paragraph 5, paragraph 6, paragraph 7, paragraph 8, paragraph 9, paragraph 10, 11, 12, 13, লৈকে গোটেইখিনি আনি দিব। It is further seen, paragraph 14, it is further seen that pursuant to the order dated 24/6/2025, it has been brought to the attention of this court by the registry that the officer who was responsible for passing a writ for delivery of possession, the judicial officer who was responsible for passing the writ for delivery of possession in respect to a non-existent decree was one Sri Chinmoy Borua, who is presently working as the Chief Judicial Magistrate, Dhubri. Next. Mr. Aminu Mahmood, the learned counsel appearing on behalf of the petitioners submitted that in pursuance to the writ for delivery of possession in title execution case number
6 of 14.
What is the number?
6 of 14, my lord. That's
6 or
14, 2014.
so and so.
LCR is there.
6 of 14. The respondents herein or their predecessor were not evicted. Only one Hussein Ali,
Hussein Ahmed Chaudhary.
Hussein Ahmed Chaudhary, who was in possession of
One lesser land.
one lesser of land.
My lord,
Yes, sir, that is in
that is
record.
the submission of my learned friend, my lord, but it is not correct.
It is on record.
My lord.
How is it?
What, are you not understanding what I'm saying? It is his submission.
No, well, it is on record. I am not.
Understood. That is your submission. I'm recording it.
Submission on the basis of record.
I'm not going to, Mr. Mahmood, you are not going to dictate my order.
No.
I am going to
You
dictate.
are answering his question.
Yeah, I'm not on that. Submitted that one Hussein Ahmed Saudi, who was in possession of one lesser of the suit land, was evicted. And as such, the respondents herein, as well as the predecessor in interest, had no locus standi to file the Ms. case number 2/2015. He further referred to the order passed by the learned coordinate bench of this court in CRP number 24/2021, wherein the coordinate bench of this court, taking into account the petition filed by the respondent herein, to the effect that the respondents would not like to submit any evidence, but only would like to call for official witnesses, made an observation that if the petitioners refuse to examine themselves as witnesses for proving the facts alleged in the petition, naturally the court would have no hesitation to hold that the allegations raised in the petition are not true. He therefore submitted that as the respondents herein, who were the petitioners, before the learned executing court, did not want to adduce evidence.
Only in respect of the petitioner.
The proceedings, the further proceedings of Ms. case number 2/2015 is nothing but an abuse of the process of the court. Next. Per contra, Mr. A.K. Sahewala, the learned counsel appearing on behalf of the respondents, submitted that in pursuant to the writ for delivery of possession issued by the learned executing court, the predecessor in interest of the respondents, Sri late Ganesh Chandra Datta, was evicted from the suit land. And it is under such circumstances, Ms. case number 2/2015 was filed before the learned executing court. What do you say about this witness aspect?
Witness aspect, my lord, what happened? This person, his voice got choked. So he was not in a position to adduce evidence. So we said that petitioner's evidence is not required, but we'll adduce the official witness. My lord may see the prior portion. Further, we pleased to allow the petitioner to take chief of the official witnesses. So that was the submission. Only in respect of the petitioner, the witness may be closed because we had no other option. He was an old aged person whose voice got choked. He could not speak out. That was the aspect.
Who was the petitioner? The son.
Ganesh Chandra Datta.
No, he had died.
His son.
No, he died. That is eventually died.
At that point of time, the Ganesh Chandra Datta was alive.
But his was.
But subsequently, now the predecessor, the successor have come in.
But
the respondents have come in. Now you want to adduce evidence.
That time also we wanted to evidence, but we want to adduce official.
Mr. A.K. Sahewala, the learned counsel appearing on behalf of the respondents, submitted that at that relevant point of time when the petitioners submitted at that point of time when the at that relevant point of time when the proceedings were going on, on account of the age-old ailments of late Ganesh Chandra Datta, he was not in a position to adduce evidence for which the petitioner sought directions for adducing official witnesses. The learned counsel further submitted that subsequent thereto, late Ganesh Chandra Datta expired, and the petitioners herein, the respondents herein, who are his successors, can very well adduce evidence taking into account that they have been subsequently substituted as the legal representative of the late Ganesh Chandra Datta. This court have also duly perused the materials on record and in detail in the previous segments of the instant order mentioned that in spite of there being no decree and an executable decree passed, an execution application was filed by the defendants, and on the basis thereof, the learned court of the Munshi Titabar, presently the learned court of the Civil Judge Junior Division Titabar, had proceeded with the execution proceedings and delivered possession on the basis of the writ for delivery of possession. The said aspect is completely unthinkable inasmuch as it was least expected of a judicial officer that the said judicial officer would not know the difference between an execution proceedings initiated on the basis of an executable decree or not, and more particularly in respect to a suit which was dismissed. Considering the above, this court further observes that as to whether by exercise of the writ for delivery of possession, the officials will writ for delivery of possession, the predecessor in interest of the respondents herein were dispossessed or not is a question of fact which can be adjudicated by the learned executing court in exercise of powers under section 47 of the Code of Civil Procedure. It would not be proper on the part of this court to give a finding in that regard. Considering the above, the instant petition therefore stands disposed of with the following observations and directions. The learned court of the question of interference with the proceedings being Mise case number 02/2015, pending before the court of the learned Civil Judge Junior Division at Tittabor, do not arise. The learned Civil Judge Junior Division at Tittabor is directed to expeditiously dispose of the said proceedings at the earliest and preferably within 3 months from the date of the present order. No, from the date of appearance of the parties. Number 2. This court grants liberty. The question is to whether in execution of a decree, in execution of a writ for delivery of possession issued by the learned executing court, the predecessor in interest of the respondents herein, that is late Ganesh Chandra Datta, was evicted or not, is a question of fact which has to be decided by the learned executing court. First, the said fact can be proved either by adducing evidence by the petitioner, by adducing evidence by the parties, or through official witnesses. Mr. A.K. Sahewala, the learned counsel, appearing on behalf of the petitioners, respondent submits that they would like to adduce evidence. Taking into account the above, this court grants the liberty to adduce evidence by filing their evidence on, by filing their examination on chief before the learned executing court. Number 3. This court directs the registry to forthwith return the records to the learned executing court. Next. Taking into account that in view of the records being called for and the stay being granted by this court earlier, the further proceedings of execution further proceedings of Ms. case number 2/2015 had not been was not proceeded with, and further taking into account that the parties are duly represented, they are directed to appear before the learned executing court on 8th of September 2025. The registry shall ensure that the records are before the learned executing court prior to the date so fixed. The examination in chief, the liberty so granted by this court to the respondents hearing to file the examination in chief is to be filed before the learned executing court on 8th of September 2025. Next. Before parting with the record, this court would like to make an observation. It is not conceived, it is beyond comprehension that a judicial officer who is presiding over courts exercising civil jurisdiction is unaware of the implication when a suit is dismissed. The concept, there is no concept of an implied decree in favor of the respondents or in favor of the defendants if a suit is dismissed. The act on the part of the judicial officer issue a writ in the nature of issue a writ for delivery of possession in respect to a suit which was dismissed shocks and surprises the court. This court would not further like to add anything more, but would leave it to the wisdom of the Guwahati High Court on the administrative side to take a call on this aspect.
My lord, the reading order, I have nothing to say, but my learned friend has said one thing. Ganesh Chandra died in the year 2019. Ganesh Chandra died in the year 2019. But my learned friend said that due to illness he could not. But this petition that they would not adduce any evidence, it was filed on 20/2/21. So that part may be corrected. Otherwise, it is factually not correct.
Chal.
My lord, two small things with my lordship. The land in which we were evicted was 3.5 luchas, but as per the rate, it was 1 lucha. The reason being, 2.5 luchas was behind our land. So what had happened when we were evicted?
I'm not going to.
You have no land at all. Where is it? The court is saying you have no
These are
land.
all before the executing.
This on item 12.
Obliged,
Judicial. None appears for the petitioner. What is your stance?
This matter, as I'm using this second copy, the court's second copy. Let
Huh?
me obtain instructions, this.
None appears on behalf of the petitioner. Mr. B. Chaudhary submits that he would obtain instructions in the matter to list this matter again on 15th of September 2025. So the counsel appearing on behalf of the PDCL shall obtain necessary instructions as to instruction.
13.
May I please, Lordship, this regarding non-payment of some supply work done, Lordship, in the year 2016, Lordship. There is Health Department and AIDC. Can I say page 21, Lordship?
What is there?
Item number 13 is a APDCL matter, my lord.
And
Item number 13 is an APDCL matter, my lord. It's perhaps mistaken.
Who is appearing? What is there? There is an interim order.
There is an interim order, my lord. The issue
No,
is
what means?
nothing remains, my lord. The electricity connection was restored. So that perhaps was done for a temporary period, man. That can be made firm.
Has been restored. That is your instruction?
Yes, I have a letter to that effect.
Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL submits that the electricity connection have been restored
Following the interim order, my lords.
on the basis of the interim order dated 9/1/2019. It therefore appears that the petitioner has lost interest in the matter. Accordingly, the instant with petition stands closed.
14.
This case, Lordship, I have filed affidavit in 2019, Lordship.
Huh?
2019, I have filed the affidavit.
What is this?
Yes, received.
Regarding
but
Lordship, non-payment of
amount
some
is
Lordship
already
dues,
received.
Lordship, I have supplied some Lordship.
On payment.
Non-payment, Lordship.
Lordship.
And what did the affidavit say?
Affidavit says.
They are
that
not
this
denying, Lordship. They said that we have submitted for proposal, Lordship.
Proposal has been submitted.
In the year 2019, Lordship. Till date, I have not received the only amount of 3,62,000, Lordship, 618.
So that was of 10,87,237.
Yes,
That is
Lordship.
the amount.
I am at present,
Purchase
Lordship.
of so and so Iman. So this is the admitted amount.
Admitted amount, part
Okay.
payment has been already paid, Lordship.
No, apart from that, you have already paid amount of Iman, but out of the days, the deponent has received an amount of rupees 3,62,000. This is your reply, affidavit. Iman only as an FOC during which the rupees were only as outstanding. Accordingly, the said amount was released to the petitioner on 30th. So he was given 3 lakh so and so.
Yes.
For the two works, Lordship.
Only as FOC during which Iman is out. So 10,87,000 remains.
Now remains, Lordship, in this regarding this work, Lordship, this supply, Lordship, 3,62,000.
3,62,000.
The Lordship may kindly see page 21, Lordship, 21, 22, Lordship.
No, you have to get how much amount left?
Lordship, now left, Lordship, 3,62,000. Look, there are two supply, Lordship. Regarding one supply, this petition is lost.
62,000.
3,60,000. Lordship, may kindly see page 21 and 22 of the petition, Lordship.
But why do they say that you are to get 10,87,000?
Regarding, that was regarding two supply works, Lordship. And this case is regarding one supply, Lordship. Paragraph 17 of the affidavit, 7 of the affidavit says that two orders.
2 work orders dated so and so and so and so, and deponent submitted sealing demand of Iman out of Iman only for purchase of hotel furniture, hostel furniture and Iman, but out of the which amount has received rupees 3,62,000 only as FOC during the year Iman with rupees 10 lakhs as outstanding. Accordingly, the said amount was released to the petitioner on 34.
Dated 34.
So it said that the deponent submitted the proposal for revalidation of so and so. So this is the amount they are saying not paid.
There
You have no instruction proper.
No, Lordship, there are two works, Lordship, two orders, Lordship, two supply order.
You are not
And
aware how much you are entitled to.
Now.
Find out.
Oh.
The learned counsel appearing on behalf of the petitioner shall obtain instruction as to how much the petitioner is entitled to in view of the affidavit in opposition filed by the respondent number 2. List the matter after 3 weeks.
Obliged, madam.
16,
Please, my lord. My lord, it is, my lord, regarding non-payment of contractors bill. Page 19, my lord, completion certificate.
Which department?
PWD, man.
Okay, summarily disposed.
Deeply obliged.
16,
Any PWD council whose name has to be put there, his name is there. Mr. B. Gogoi. Mr. B. Gogoi, this matter I have put it as summarily. How much summarily is not it? No fixing a date.
Only thing, well, that verification may be given.
Everything.
After
It will be
verification,
done
whatever
as
is
per
due.
summarily.
Fine.
What is this, Mr. Agayan, Miss Agayan? What is this matter?
May please your lordship. This is
Ah,
the cancellation of license, my lord, for that railway, my lord. That is, the kindly see page number 25 and 26 of the writ petition, my lord.
25 and 26. What happened?
And yes, my lord, the person was convicted, my lord, that pleaded guilty, my lord. Convicted means, my lord, for 2 cases, my lord.
So now,
Now, my lord, kindly see my instruction, my junior PDM.
what is that?
They have the, my lord, as per rule 11A, my lord, kindly see that instruction, my lord. 11A, my lord. Not with understanding that the license may be cancelled by the DCM at any time with the assigning any reason thereof, SS, SMS are authorized to discharge the
You are
license.
involved in any of this?
Yes, my lord, in 11A, happen.
The petitioners, they pleaded guilty, my lord.
Huh?
They pleaded guilty on the first period.
What case you have?
Now, my lord, and thereafter, my lord, license has been cancelled, my lord. We file an appeal. They have not considered.
The question does not arise in view of 11A.
This is the not mandatory, my lord, because before, my lord, cancellation, my lord, minimum, my lord, procedure, my lord.
What procedure?
No show cause, my lord.
No, okay, let us assume that you are given a show cause. Then what happens?
And the nature of gravity of the offence is also they can consider.
What is the offence you have been?
My lord, offence in the FIR, my lord, that we charge, my lord, higher rate, my lord.
184. 384 is what?
We are, my lord,
What is 384?
extortion, my lord. But here, my lord, the extortion is not there, my lord. We demanded, my lord, 100 rupees extra, my lord, for carrying, my lord, baggage. We are porter, my lord. Railway porter. This is the allegation.
Extortion is there.
FIR we have translated, my lord. We have annexed, my lord. Page 16. In one case, our name is not there.
Madam, you file an affidavit. Let them be also satisfied with something.
Yes.
Ms. Agayan submits that she would file an affidavit in the matter, taking the stand of the respondents. Mr. Ali, appearing on behalf of the petitioner, submits that the matter has already been delayed. Mr. Taking into account the above, this is the matter on 17th of September 2025. The affidavit be filed by 10th of September 2025.
Must oblige.
Yes.
Yes, sir. 18, my lord, can we fix any other day, my lord? Yeah, the fuel and power purchase price adjustment, my lord. Fuel and power purchase price. Yes.
Yeah,
file that.
Okay, we'll do it. Anyway, we'll do one thing. There are many matters out there. Na? Those review petitions will dismiss it. Where are those review petitions? People, hard cow will be there to dismiss those review petitions. Then you can take the dates. Mr. Any
We have one item on 19.
Item number 19, we are for the post.
Item number 19 on next 19.
You have got 119 date? Oh no, okay, 19th.
Yes.
Item number 19.
What is the matter about?
Contractual matter, Miller. There is a stay order.
Okay, 19th.
And interim order will continue, my lord.
And there is an application for vacating that interim order. So
Is 226(3)?
no, my
No.
lord, not 226(3), but the matter was heard at length earlier.
So 19.
In the batch of those matters.
Ah. Item number 19.
Now it will keep on coming.
I finished up 2 only. 19.
Now she was looking for item number 26, which was mentioned in the morning.
Ah,
Fix it in the.
we listed after 6 weeks.
No, that should be next week. one.
Well, no time. Your junior is always asking for time. And help.
Second week, let it be in second.
Where?
After 2 weeks or so.
Okay. List the matter on 29.
May it please your lordship.
Interim order passed earlier shall continue till then. He said that there was no interim order in the mornings. Didn't you say that?
Not today, Lordship. Today,
Then
May it please your lordship, my lord. Malad, item number 28, my lord, tender matter, my lord. We have agreed, my lord. Kindly fix a date, my lord, here, this matter, my lord.
6th of August.
6th or 7th one, 6th.
what is the matter about?
6th of
My lord, my tender,
Stay?
stay is not there. That is why urgency is there, my lord. Stay is not there.
6th or 7th?
7th, my lord, yes.
6th, Lordship.
7th, I have another matter.
6th, Lordship. Kindly fix it.
6th is
6th.
okay.
Kindly on
6th.
7th, my lord, address.
6th.
Yes,
6th.
deeply obliged.
2 p.m.
Yes, my lord. Obliged.
Wherever the interim orders are there, if you want a vacating out there or anything urgency is there, then you put him to that and we'll put it serially, primarily at 2. But have to have these done before 22nd, because from there I won't be there for 2 weeks.
Item 21 of the agreement, it should be sure, maybe listed after. From the week.
Get a date from there. খালি সিরিয়ালি করে নেবো, হ্যাঁ বেশি নিয়ে দিব, 3টা সাইড আজকে বেশি।
Item 1, supplementary list item 1.
Well, today one progress report has been submitted. In High Court cases are very considerably, my lord, they are still going on, my lord. There's good progress, my lord. So far is, which are pending before the Honorable Court. But so far, your lordship kindly see page 1, my lord, of the report. Item number 1, Dibrugarh session case.
Report.
Page 1. So far is Dibrugarh district concession case number 95 of 2003. There are 270 witnesses, out of which 111 witnesses who have been examined. So this is one of the oldest case, 2003.
Which matter? Where do I find it?
Page number 1 of the report, my lord.
31/7/2025 report.
Yes, my lord.
As on 31/7.
Yes, yes, on 31. The latest report.
For answer and take it. What is 2005?
2003, my lord. There is a session case number 95 of 2003. Case number is there, my lord.
Yes, yes.
So additional public prosecutor asked to pursue the case diary and take necessary steps for summoning the material witness to SGO the expedite disposal of the case. Case is fixed for evidence on short paper suspension. Till probably more than 100 witnesses to examine, my lord.
Free matter is going on.
No, my lord, actually, we are just this honorable, this is only monitoring bench, my lord. So that's why time to time this report has been submitted.
Is this a monitoring bench?
Only monitoring, my lord. As per the higher court order of the Supreme Court, my lord, apex court, my lord, that is Osini Upadhyay's case. This question here.
এই আমার নোটিফিকেশন কনফার্ম করতে আমার
My lord, your lordship will find an order dated, my lord, 25/9/2020.
Where?
The order of this honorable court, my lord, 25/9 and everything your lordship will get there, my lord.
So what is required to be done?
Well, just monitoring, my lord, time to time, my lord, that law.
Understood. What is to be done?
If there is yes, any, your lordship can regarding that, suppose, my lord, the item number, serial number 1, Dibrugarh's case, my lord, it's a 2000 matter. So, my lord.
It is a, yeah,
2004.
Mr. Nath, why is this matter getting so delayed?
I got the
Sessions case number 95/2003.
Yes, Mr. Nath, now there are director of prosecution. Yes.
this report, I'll take a copy and I'll get the account.
And now with a proposed date, how will you produce? Because most of the cases, what we have seen is for non-appearance of the witnesses, prosecution witnesses, trials are getting.
That will expedite, my lord, because this instruction, my lord, I'll take a copy. I don't have the copy right now.
So another matter, my lord,
This will be taken care of.
that is one of my.
We'll take care of that.
You take note of what, Mr.
Yes,
Mr.
yes.
Then, my lord, another item, that is, my lord, your lordship will find in serial number 13, page 3. Page 3, serial number 13, my lord. Additional code CBI, special case number 81 of 2004. It is also more than 21 years ago.
Serial number?
13, my lord, page 3. Of course, there is lots of witnesses. There are 482 witnesses. Until now, only 132 witnesses were examined. In those old matter, my lord, your lordship can pass some order to expedite the matter.
See, that is what again, prosecution is unable to bring sufficient
Bring
numbers of witnesses on.
Same reason, my lord. So these are the two most, especially, my lord, most one of the oldest cases, my lord.
Really.
This is item number 2. This is a land grabbing case.
My lord, 2014.
It's a land grabbing case. Land grabbing case is taking such a long time. After this is in session special land grabbing case means is it at the stage of the civil side or in the criminal side?
First, my lord, civil side, then probably.
No, what is this case?
Yes,
This
my lord.
case?
Status, my lord.
Because once it is if it is a land grabbing case on the civil side, because once the civil side is over, the criminal side has very limited role.
Limited role.
Then why is it taking such a long time for a 2014?
14, more than 11, 12 years, my lord.
The very legislative intent of the Land Grabbing Act
Will be
was
frustrated.
6.
Will be frustrated, yes.
Yes.
So your lordship, my lord, in respect of that case also, your lordship.
This ground should not be there in the report, COVID-19 and all. Those
That,
days
my
are
lord,
gone.
that is.
What happened after
For COVID-19, now witnesses are not examined, witnesses are not appearing, that is cannot be a ground, my lord.
Same 2015 case also. Non-executions of someone.
And what is happening to this, the other one, page 6 out of 9?
Which one?
Kasar, that is disposed of already. from 2015, my lord, execution process returned without execution. Fresh non-bailable warrant issued upon the appeal. Accused is yet to be appeared.
Now another one is of 2011.
Yes, my lord. For appearance, these are all appearance.
See,
How is it possible?
So let there be an order passed to the prosecution director to take special care of those cases, man. At least. Yes, from 2011, man, still in the minor stage of appearance.
Now, does the director of prosecution have a role in these matters?
Actually, directly not there, but my friend, my lord, who is representing state of Assam, he can, my lord, who expedite our aim and object of this.
what is the power of the director? What and role and
Oh,
responsibility?
yes, that's.
Because they
yes.
only come under the BNS,
Yes, they come under BNS and they can, my lord.
BNSS.
Yes, yes.
If they come under BNSS, then obviously in respect to these proceedings are prior to that.
Prior to that.
So therefore, the question of BNSS is
Not
coming into the picture. So the director of prosecution have no role. Do they have a role out here?
Since BNSS doesn't come. As per the BNSS, he has no. But as of now, the entire.
Whether execution was there, DGP could have. See, it's a case of prosecution.
Yes.
You allege that so and so has done this.
All offense against.
Now you'll have to bring your witnesses.
But the official witnesses, we can very well take care of. And
Most of them are official. Otherwise, also you'll have to collect their address, serve notice.
Since the report has come to us, definitely we'll take it up. And as regard the execution of someone or the process, that also we'll see why it isn't done.
But 22 years for a prosecution to continue. Means first of all, you also have to think about the predicament of the accused also. They are under a cloud.
Right.
And on the other hand, some witnesses may die also. 22 years is a very, very long time.
Long period.
And we are still at the trial.
Appearance statements. In some cases, appearance statement.
How do you chalk out this problem?
Let us examine the report, because the report has come, and after the report, the witnesses, as Lordship has indicated, these are official witnesses.
No, suppose you find also that there are delay. How and in what manner we will have to get the result? That is what we are asking. Through whom? If not prosecution director, then whether by PP, Director General of Police, who will do this? We want that.
Ultimately, as on today, he is the main person. The Director of Prosecution is playing the role of a nodal officer among all the public prosecutors and the entire system. So, since here I have seen that the prosecution side is instructed to issue someone at least 3-4 witnesses. So that can be expedite, and we can.
Can Director of Prosecution remain present one day to assist us?
Yes.
Because what happens is that we thinking that roadmap has to be there.
Yes.
The roadmap, as you were saying, that the Director of Prosecution now will deal with pre and post also. BNS. So he will be looking after how to manage the prosecution. Yes, there will be some additional public prosecutors who will be now recently appointed, or PPs will be appointed now, as we could hear from your Chief Minister. Saying that there will be some public prosecutor and will be appointed this month.
Yes.
And they will be undergoing some training, and then from next month onwards, they will be on a monthly remuneration. That is another thing which is required as per the BNSS. But there is also a thing that as regards the earlier part, the earlier people will be looking into it. But overall, is it the thing that the director of prosecution would be the person concerned who would be manning both the, looking after that, both the pre and post? This thing will be looked after how the proceed with this. If this is so, then as we are not asking this matter, this bench is only for the purpose of monitoring, so that we can get a better understanding of a roadmap.
Correct.
Because it could be, you will be abreast with, I think, those fact situations, why the matter is getting delayed. You may not be in a best position for that.
That's
So if we can ask the director of prosecution to be present when the matter, this bench is being taken up. Why I want it? Because this is for monitoring and he will be the best person to say so.
Yes, yes.
And look at the things, this is only relatable to the
MLN
MLN
MPs.
MPs only. What about others? We are not monitoring that, but that question comes to our mind.
That Lordship may fix the matter, but I'll definitely apprise the petition and all the reports and all, and then accordingly we will come up with a roadmap. How, to what extent, in what manner we can proceed.
Give us a roadmap in respect to those matters, because in the High Court, there seems to be only one division bench matter.
Yes.
Only one division bench matter, the two of 2021. All our other single bench matters which are being taken out by my brother. There are new matters out there.
And all are fixed on 8.
All are already fixed are hearing, my lord. Fixed for-
Most of them
And
are
already-
fixed on 8
yes.
Friday, because
Yes,
in
yes.
some cases, no service, nothing like that. All cases are already over. One old
One
pending.
2013 matter is.
One is there, that is a part, hearing is, one part is concluded, other the reply is there.
Heard Mr. T.J. Mohanto, the learned senior counsel, as well as standing counsel of the Guwahati High Court. Mr. Inan appears on behalf of the state of Assam. Miss, what about your state? What is happening?
But we have been furnished with a list report. Therein,
You have a director of prosecution.
Not yet.
You have not appointed.
Not yet.
Where is Arunachal?
Process
Mr.
going on as well.
Where is the Arunachal list?
A universal list, my lord, your lordship, page 8, my lord. That is, my lord, since 1996, my lord, one matter is pending. Bandodua. That is, my lord, page 8, my lord. Your lordship, kindly see page 8.
1996, one.
96, 2005, and one is 2000, one is 2005 ones. Serial number 1, 2, and 3.
And Mizoram?
New case pending.
Those are from
And Nagaland?
Nagaland.
No. Mr. Arun Chandran appears on behalf of the senior government. Arunachal Pradesh appears on. But Arun Chandran, the learned senior government aid Arunachal Pradesh. Charlie, Edition, Irrigation and growth. Additional education. Based on the report was submitted by the registered judicial that in the principal seat, there are certain matters pending which are certain matters pending with dates fixed. However, from the report of the long pendency of the criminal cases in the district judiciary, of Assam, it is disheartening to take note of that there are various proceedings pending for decades.
Against the body.
And more particularly, reference may be made to sessions case number 95/2003. And special 95/2003 pending before the court of the, which court? Before the additional sessions court, Dibrugarh. As well as the special case number 81/2004 pending before the additional court number 3, CBI, Kamrup Metro. The list of the long pendency of criminal cases, more particularly pertaining to the sitting / former MPs / MLA, have also been furnished to Mr. D. Nath. It is also pertinent to take note of that before the court of the additional chief judicial magistrate Kamrup, there are various matters, various proceedings pending at the stage of process returned without execution. And in one case, this is disposed of, no? Pending with. And there is another case pending before the, what is this? Nagaon is what?
Serial number.
2008 for appearance.
Another 2 proceedings before the courts at Nagaon. It is relevant to observe herein that the cases which are pending at Nagaon are of the year 2008. And from the registration, it appears to be complaint cases. This court further takes note of that in respect to the state of Arunachal Pradesh, there are 3 proceedings which are pending. One of such proceedings is almost three decades old. And the other 2 decades old. We have been made to understand that the Director of Prosecution, who have been recently appointed for the state of Assam, would be in a better position to provide a roadmap insofar as the prosecution of the matters pending in the state of Assam. pending before the district judiciary of the state of Assam. When can he provide a roadmap?
But if lordship fixes after 15th of August, it will be good.
We'll have it on 20
August.
Insofar as the state of Arunachal Pradesh is concerned, it has been brought to our attention that there is no director of prosecution appointed till date. We have also heard Ms. P. Machaji, the learned additional advocate general, Mizoram, and Ms. M. Kechi, the learned additional advocate general, Nagaland, who submits that there are no cases, no criminal proceeding presently pending in respect to MPMLE. Taking into account the above, this court fixes this match, fixes the instant proceedings on 28/2025. On the same day, the director of prosecution, SAT, shall be present, and he shall provide a roadmap as to how the proceedings before the district judiciary of Assam, which are mentioned in the report, can be proceeded with expeditious, and more particularly those matters which are the reference of which have been made here in above. Mr. A. Chandran, the learned senior government advocate, shall also give a roadmap as to how the three proceedings which are pending before the various district judiciary in the district judiciary of the state of Arunachal Pradesh can be expeditiously dealt with.
That three cases are being regularly listed, Lordship. The three last orders I have put.
That we have also seen.
I also know these are listed, but the thing is, the witnesses don't come. How do you go give us a roadmap? How do we proceed?
You are the prosecutor.
You are the prosecutor. You have those people. You can't keep on making it slow. We can ask the court, then look here, you proceed, but the court is handicapped, taking into account that there is no witness who comes. You don't bring the witness and this is getting delayed. And later on, you may say that we have been we suffered on account of being not afforded the opportunity. 20 years or 30 years, I think is a good time.
For it.
Mr. Dina, I want to put a question to you. Apart from that, this is beyond the matter, written matter. I've been told out there that in this, there is a big problem in of the UTPs being brought to the court.
No, sir.
The state is not providing the resources.
But I have
This is a very serious aspect, taking into account those UTPs are inside.
True, Malad.
Their rights under Article 21 is being violated.
Lost. Malad, I have.
Because if they don't appear, then the question that the matter gets delayed. And at the end of the time, because of the delay, either the prosecution's case is also hampered, and the rights of the corresponding rights of the
I have taken up the matter with the Home Department that in two, three district, it has come to my notice, and I have already because of non-payment of some bill to the contractor who used to provide the car from jail to court. That
You have to
because of
provide.
that
There's
has to
no
be,
way out.
that has to be, my lord. I have
Because
already apprised them.
Petition doesn't, right? They have a right.
No.
You don't provide means it, 1 day extra, if a person is behind the bars, it will amount to illegal detention.
Some video conferencing thing they have is at some places video conferencing has been it has been done. So video conferencing, but this is a problem that I have
Why
asked them.
do people, they don't come when I'm taking bench for? And file a writ petition, non-payment of bill. I can pass an order in that regard. But then not being the UTPs out here, that cannot be a good reason.
In 2-3 districts, the problem is severe. I have taken up. I have already asked them.
Food supply, food supply.
তথাপিতো কি জেলত আমাকে পেট্রোল তো পাম্পত বিল দিয়া নাই পেট্রোলত বিল দিয়া নাই এখানে এটা জানি দিয়া হৈছে
Yes, Mr. Arkadev Chaudhary. There are two matters. One matter is this, there are two matters out here.
Yes.
Which is in Assam, which is delayed. One is of 2003, that's the Dibrugarh matter where the director of prosecution can help it. But as regards 2004 matter, it's a matter which is pending before the CBI.
Lordship,
The CBI is your jurisdiction.
they have got a counsel here,
Who is the sending counsel now?
Manorama Kumari.
For High Court?
Anyway, I will take it up with her lordship.
Are you appearing in these matters? No.
In the next case.
Next case.
No, in this matter,
No.
the earlier matter.
No.
Push the, eight on just. Ako, yaw naam tu horay di ba di? Arkadev Chaudhary, the learned- In respect to 2004, it was an additional the pending assembly court. And additional CBI court 2004 pending also. In respect to so and so, which is pending before the additional CBI, additional court of so and so CBI. Mr. Arkadev Chaudhary, the learned so and so, shall provide a roadmap as to how there can be an expeditious disposal of the institution. The name of
Item.
Mr. Arkadev Chaudhary, which shown in box. Yes, they know about. Yeah, motivation.
এখন দিছে তো গভর্নমেন্ট এইখন আমাৰ কপি হিষ্ট্ৰী ফৰম উইকত এখন আহিছে ৰেল লেবৰেটৰী তোক দিয়া আছে কপি এইখন এটা আমাদের যে এখন আমি ফাইল করছিলাম এই ইস্যুটোর দাবি থাকি রিগার্ডিং মেইন ইনফ্রাস্ট্রাকচার দিস ইজ উইথ রিগার্ড টু ল্যাবরেটরি
This file sheet.
Yeah. Original order to first order, how this bench was constituted. Office note sit file, there is office note file give that.
Yes.
May please, your lordship. Look, basically, in this matter, we are concerned with the infrastructure of the subordinate courts.
Of the?
Subordinate courts in the state of Assam, Arunachal Pradesh, Nagaland and Mizoram.
Not only subordinate court.
High Court also? Yes, my lord. Yes,
It
sorry.
relates to infrastructure
Infrastructure
of courts
of all the courts.
of all the northeastern
Correct.
states.
Correct, yes. Now, on the last two occasions, the issue which is flagged before your lordship is with regard to, my lord, lavatory facilities in the courts. And to that effect, the state of Assam had filed one affidavit, additional affidavit, dated 29th of April 2025.
Nobody from registry today?
Lord, Register Administration, I am told he is out of station, and I have informed Mr. Devashish Kashyap. I have not taken, but. In response to this affidavit, my lord, on the part of the registry, there is a response which is placed before your lordship.
What are the issues today or today's
Today, my
deliberation?
lord, if your lordships kindly take the parawise comments in response to the additional affidavit filed by the government. This is the contention of the registry, my lord.
Where
Basically,
do we
it
get
states,
that parawise reply? Okay.
yes, my lord. Basically, it says the government has determined that an amount of rupees 723.99 lakhs is required for renovation and upgradation of the lavatory facility in the state. Now, here, my lord, our contention is that, my lord, out of that total amount, only 3.32 crores, which is just in half of the amount, has been allotted
for financial year 2025 and 26. Perhaps that is not sufficient to cater the needs of the public as well as the requirement of the infrastructure.
But can not it be done in a phase manner that these are the most first preference should be
Yes,
here?
my lord. Yes, yes,
See, finance may be a problem
yes,
for a state also.
yes.
So instead of maybe subject to what my brother says, getting all the money together,
Correct.
can't we identify that these are the core issues? First preference should get, these courts should get first preference.
Yes, my lord.
It's a very pathetic condition. That in that manner we can have. I mean,
Yes.
Chaudhuri is also there. He is also raising the same issue.
Yes, my lord.
Isn't it?
Yes, my senior is also raising the same issue. If we can take
Toilet.
if we can
Toilet, what has happened?
sorry, my lord.
What has happened in toilet?
My lord, there was a plan and estimate taken. Yes. If your lordships take up the affidavit of the government, page 1556, my lord. The total amount determined is 723.9896.
No, affidavit separate file is there.
1556.
Give the affidavit file.
Come to Nagaland or everything.
We are going to put it in. Yes, that might be a video. It's over now. Yeah. Bottom break. Let's start it. Oh, yeah. Put problems to the these kind of so they have no. It is good.
These are the 30 locations
Yes, my lord.
for having toilets.
Yes, toilet is there, but in a dilapidated.
So what is the cost on the basis of this serial number 1 to 30?
Government
Total
has
as per proposal of High Court?
723.9896.
This is
total.
Total.
Out of that, 3.32 has been approved.
So according to High Court, which are most important, where first page it can be started and.
And where's the finance not there? Finance? Where's the finance?
Finance is required in this bench.
Finance.
Normally, the AG approves. The additional AG appears, therefore finance is not separately asked to come because he takes care of.
No. Finance has to be there.
And PWD, finance and
The
PWD.
bottleneck is two.
In
It's
response
because
to
of the finance and the person implementing is the PWD.
PWD. This
PWD, I know he can do it.
But finance.
But finance is a big problem, and these
I think
two,
there is a direction
there are
on earlier occasion.
councils of the finance who creates the most hurdles. Mr. B. Gogoi or Mr. R.
No, no.
Gogoi, any of the both of them.
I think there is an order directing Mr. Gogoi to remain present, and I think there is a order on last occasion, whether his name is reflected in the cause list. Order so first.
Well, I have received the response to the pairwise comments given. And I am told that serial number 1, 2, 6.
Yes,
serial
no,
number
name
one-
Name shown?
Yes, yes.
Serial number 1, 2, 6, these and serial number.
We direct the Commissioner of Finance to be present in the tomorrow.
Well, serial number 1, 2,
No.
6 and 10, these work are complete.
We direct the Commissioner of Finance to be present. This is not how it works. Because why the finance is not here? It's not done. Without the finance, how can it ever? Here is a case that 3 crores 20 or something has been given out there. The demand is 7 crores. Now, why the finance is how the finance is going to defray the cost? This is not how we are doing it. We are not doing it for the good of anybody. It is good for the public. And your government does not want that there should be a proper laboratory system where the Supreme Court has been telling everybody that you need to have it?
Kindly take my instruction for a moment.
No, this is not done.
In response to the pairwise comments given by received from the registry.
332.
This is my response, Madam.
Tell us, what is your response?
Serial number 1, 2, 6 and 10, these are completed work. And Madam, the amount total, kindly see the 475 is the total amount. Well, all works are not repairing. Well, some are new work, some are repairing work. They have
So according to you, serial number 1, 2?
1, 2, serial number 2, serial number 6 and serial number 10.
1, 2, serial number 6 and 10 completed.
These are completed work.
When?
As per my instruction. Madam.
When completed?
Work,
And when registry has given this? Tell us.
work, they have indicated me, I have received the
When
instruction
completed?
today.
Because otherwise registry is wrong. Sending in these reports that even after completion they have submitted report. Or it has been completed after this report was prepared. Please tell us what is the date.
Lord, since
Not
in
done.
their affidavit, they have given the amount, but they don't give the details of the work which were involved in particular districts, my lord. So that's why registry has prepared this, giving the details of the work. If your lordships kindly take up, say for which are involved in that amount.
And Madam, the administrative approval has been given to other works and kindly see from serial number.
If your lordship see
Serial
the
number 22 to 30, these were approved by the Honorable Court on 16/7/25.
Okay, fine.
So administrative approval to these works, it is not given yet.
So do you want to say that all others administrative approval is given?
Now, we have indicated administrative approval issued. We have indicated, kindly see the second last column. Madam.
Where is that?
I have given the instruction. Madam. Just now I have given two.
Okay, this is.
Yes. I have given 2 copies. The second last column, kindly see. Administrative approval has been issued. And the date of administrative approval we have indicated.
So those administrative approvals which have been granted in 2024, they have been completed.
1, 2 has been, according to my instruction over phone, I have received.
But why this has not been given when you have prepared a nice table with instruction? Ought to have been the status of the project. Completed, half completed, not completed.
This instruction, we have.
You complete this instruction, give us what is what.
Yes.
And where is finance?
We'll give. We have received it on first, Madam. Today over phone, I have received this. Just I have taken the print out. In
See,
detail.
that is very vital information.
Well, please.
You have given a date, okay,
Yes.
administrative approval date.
Yes.
But what happened thereafter? Tender issued, construction started, completed, not completed, handed over.
They are preparing. We received the pairwise comments on 1st of August, and we have asked them to apprise us the position. Today, some information they have given. Some time is required. We'll give. The Honorable Court approvals that we have given in the month of May from serial number 19 onwards, 19 to up to 30. in the month of May, my lord, the honorable court has approved.
Administrative approval then. I think, Mr. Not after administrative approval, what is the issue? What is to be done?
After the approval, my lord, ultimately the work will be executed by the PWD.
No, no. Administrative approval is final. Financial approval is done. Can the work be
My lord, for
started?
my lord, as over telephone, whatever instruction I have received as per.
We
that, my
want
lord,
to know the procedure. After
We have-
administrative approval is issued, what are the next stages till the completion of the building?
my lord, the budgetary allocation for repairing and for new work we have, my lord, to some extent we have. And after the administrative approval, we have to send the matter to the PWD. They will issue the tender and all these things, my lord. My lord, the detailed position, my lord, we will apprise the honorable court, my lord.
Now you see, these toilets. Is repairing and new toilets which are there, repairing too, it has to be done. Repair renovation of staff toilets at Old Heritage Judicial Court Building, Dibrugarh. My goodness. Yes, Mr. B. Gogoi, the finance guy. What is this? Do you require after administrative approval any financial approval?
Probably it will have to be there.
Huh?
It will have to be there.
It has to be there. After administrative approval.
So para 7 of their affidavit, state's affidavit, they have said it. After approval of the Honorable High Court, the same would go to the Judicial Department where administrative approval is granted as per the allotted budget and the work executed by the PWD. As a result, the roadmap, timeline and availability of funds for implementation of the model design of laboratories across the judicial institutions in the state as directed to the Honorable Court is subject to the above process.
Are you saying that, are you putting it in the global head?
But that without instructions. I
No,
can't
therefore,
regarding approval part.
first and foremost, who is appearing for the finance?
I'm appearing.
Then why don't you have the instructions?
Mr. Gogoi, this bench is a special bench.
Minor.
It's very important.
Lots.
Generally, we would have expected AG to be here, but on last occasion, as we recall,
Lots
we
of-
specifically said that you will be there.
Yes, yes. Actually, I was not aware about this matter. My lord. So,
Importance,
but I will have the instruction, my lord, on this point, my lord.
So you give the list to him
Lot.
also. He is saying there are administrative approval issues.
Yes.
What next?
My lord.
Whether construction can be straight away carried out, or we'll have to that sealing business, FOC, what not.
Ceiling probably, my lord,
No,
will come
I'm
only at the time of
just giving you
payment.
an
Yes.
example.
Yes, yes. It's
From
the
this
final-
paper, it seems that yes, it is at least this the toilets can be started tomorrow, and
Not-
he's saying some projects are already completed.
Well, for
Concrete
starting the
instruction-
work probably, my
These
lord.
are all given
Got-
2000, except from 22 to 30, which is of 16/7/2025. All are old.
In fact, from 19, serial number 19,
From
Serial number 9.
up till 19.
May.
May.
No,
20
up till
up-
16. Till 16.
Up till
these are of
16 or 24,
2024.
2024.
17
Mr.
May.
Mr. Gogoi, I don't understand one thing.
Lots of.
You see, these toilets are not luxury.
Lots
These are
of-
basic
Yes,
amenities.
yes, sir.
I think you should impress upon your state government. Apart from other things, these toilets are basic amenities. I don't understand. I would have understood for making a big building, you may have a big problem.
Lots.
Okay, it can be postponed. How can you postpone for toilets?
Lots of.
These are basic amenities. On one hand, Supreme Court has been passing orders granting various directions that toilets has to be there. In fact, there is also a PIL filed by our the counsel, Mr. B.D. Kumar. I think Rajiv Kol
Correct,
has filed.
correct.
There's a specific direction by the Supreme Court.
Yes,
My lord.
It would be that non-providing these fundings are contrary to the directions passed by the Supreme Court.
I will have the specific instruction.
No, you have the specific
Yes.
and kindly express, let the officials know that our, this court's intention about this thing, that there is a direction from the Supreme Court also as regards the toilet. So you have to do the needful to that effect. The funding of 3.232 or something, all these things doesn't work. If your PWD wants, although your PWD's quotation always high, that's a different thing. We're not saying much on that. But whatever may be, if your PWD is saying this thing, whatever may be, you have to get it done.
Lordship.
We don't know if this is the figure. We want the administrative approval as well as the judicial department as well as the finance department has to give the approval, whatever may be. Because this we are not asking you to make a good building out there or any big building. We'll consider it later on. These are basic
Some are, most of them are repairing and some new.
These are basic amenities. They're not stopped.
Lordship. 19.
When do we have it?
And
any day convenient, I will have it now. Within a week, I will have the instruction.
Kindly let the officials know that these are basic amenities.
Lordship.
You have to get it done. We are not concerned. Because if this is not there, the toilets are not being provided, good toilets are not being provided, what then? There's no toilets. In some cases, there is no toilets. In some cases, there are toilets, but no person, neither of you would be in a position to go there.
Lordship.
Have a look out there. At I don't know. When I was practicing out there in the Kamrup and the district judiciary out here,
Lock and key.
which is the premier, most premier. You can't go nearby. In fact, civil judge one court, you can't do argument for long hours, taking into account that if they opened up the window because of the stink. Luckily, some good sense have prevailed, put on the AC, then it is better. But what do you do on winters?
Well,
and what are the other issues? This is
One issue, my lord,
anything from Assam today?
Assam, my lord, in this topic, Assam is, this is the status. So far as Arunachal is concerned, my lord.
No, what about Assam's other issues?
Other issues?
That quarter, building.
Yes. That, my lord, we, in response to their affidavit.
We first today look into the basic amenities.
Fine,
that
ma'am.
is toilet.
Fine.
Once we get the toilet thing, 7.82 crores.
Yes.
Then we go further for the next one.
Fine.
But first we need this 7.8.
This is the most essential.
Or if the PWD thinks more gracious enough and comes down and the contractors out there do the work at a cheaper price, it's another thing, which you may very well.
My experience in this matter from beginning is that whenever such type of issues are here, government always wants a push from this court. That is my experience.
Push will not only push, will throw also. Don't worry.
That is my
the thing, it will be done. Okay, let us take up. Yes, Mr.
More pushes only. Many other things will come now.
Mr.
And I am grateful.
Mr. General Nagaland, you were there?
Yes.
I could see an affidavit filed on your on behalf of the state of Nagaland that an amount of rupees 80 crores have been sanctioned. You have made the payment. Okay, what is happening as regards this means the total amount is how much?
We have, this is not a grant or something which we expected. It's a type of special assistance which is actually in the form of a loan, interest-free loan. But then we had to opt for it so that we can go ahead with the project. We were not considered like the other states, my lord, where most of them was borne by the center. We came unfortunately under a different scheme for whatever reasons. So as far as this 80 crores is concerned, we have specified in the affidavit as to how we are going to spend it. And the money should be spent only for the purpose for which it has been given. An affidavit to that extent has been filed. I think in a few months' time, this will be positively utilized so that we'll be inching close to the completion of the work. The amounts required more are a little bit more, but we're just seeing how we can adjust with this. We have met the law minister a few times, my lord, and he has given an assurance when he came to Nagaland, when he met the Honorable Chief Minister also, that he will take care of it. Unfortunately, there were some bureaucratic objections as to how they can give the funds. So as an interim measure, they have given this special assistance for which we are very grateful. And we are going ahead positively.
So
Money
when
has
do
come.
we see the opening? We are having the opening of Arunachal on 10th.
Yeah,
When do we see the opening of the
I think it will
High Court of Nagaland?
happen
Not the High Court
shortly.
of Nagaland, the principal, the permanent bench of Nagaland, the beautiful site.
Yeah, it should happen very
It's
fast.
only remaining, I think it's only the furnishing and all. Remaining
There
is
are
done.
a little more intricacies are there, my lord.
The
And right
interiors
now,
are left.
the monsoon is at its height. So they say that though we can do it in 1 month, 2 months, 3 months, 4 months, they keep saying that. But natural problems are also there. But I believe that we are inching close to the view of what your lordship is saying without making any specific time commitment. But since this money has been given, and if utilized properly, I think substantial progress would be made. And we have to ensure the fund is utilized for the purpose.
Not so far, if I remember correctly, on the last occasion, this honorable court, although not incorporated in the order, wanted a timeline from the Advocate General
Yes,
Nagaland with
tentative,
regard
we are
to-
not saying that it's a strict timeline, but a
Exactly.
proposed timeline, how, when, this was an
Because money has
oral
come.
observation during the last.
In fact, this
The
80 crores.
date I have joined as a judge, Mr. Advocate General. Every December, whenever I go there, it will say that it will be finished by March. And the 4th of March, there have been 4 different March which have passed by, then nothing has happened.
But
Last year, I think we were there, me and
Yes, sir.
Honorable Chief Justice was there.
Yes, sir.
Almost everything is completed. Only the chairs and all these things were required, the furnishings were required.
It's not just that, my lord, the chairs, etc. There are more intricacies in it. Some more construction is required. The bungalows have to be done for the different honorable judges, and even a specific area for the honorable chief justice
For the
bar council.
you already have those quarters for the judges.
So, in fact,
But as regards the building, I think you need to complete it.
we are in the process and we are inching very close to it. If because of this timely assistance, special assistance, we are able to move forward. I think your lordship can rest assured that we are on the right track now.
Mr. Advocate General will require a timeline. And I know if you give a timeline, you will be able to get it done.
We will take care of it. You can leave it to me. I will look into it.
Huh? Let's have a timeline someday.
We will do
Let's
it.
have a timeline when it is being to be done.
Correct.
Because then
Correct.
also people also of Nagaland, I think, has been wanting for this high court for all.
That's right. That's right. In such a beautiful place, location, etc. Everybody is
And
aspiring to.
you put in your good word and your good office, I think it can be done. There's no
I
worry.
think we are honestly looking into it, my lord. Honestly looking into it. We'll do it. Though I know that there's no justification for inordinate delay in such matters. It's really uncalled for. But taking into consideration various factors, we'll definitely be progressing very fast. There won't be an occasion for this honorable court to remind us to move faster. We'll take all steps. Rest assured.
No, it's okay. But the thing is, I think we'll, on the next date, you kindly ask your people and give us a timeline. A tentative date.
Tentative projection.
Not on the administrative side. Administrative side, I've got 4 March. But here on the judicial side, we require something on more concrete.
We'll come up with something.
Let's
At least
put it on
let's
the
hope
next
that this
day.
80 crores is utilized in time positively. That will be a very great achievement as far as I feel. Without any hindrance, the work is done properly to the satisfaction. We don't want any shortcuts by pushing it through very fast. We've seen what has happened in the past, so we are monitoring it from every side. That's why I said,
But there has to be a stop. It's something like this. It is something happening in when you have your personal home and a particular, what you call the carpenter or all these people come in, it means they don't try to leave. I think these people, all these contractors have to leave and give us the site for the purpose of the High Court to begin. Something to
now we
that.
are taking special interest, and be rest assured that we'll be able to achieve it. After all, it's very good for the state, for people of the state. It's a great privilege to have a high court like this, which we have not had since the inception. We have the second high court according to the protocol.
It will be only now only Nagaland doesn't have only the magnificent structure of a high court.
Mizoram is having.
Mizoram had Arunachal, we are having on 10th. So I think we need a tentative date. I know you can get it done, and your contractor, as we had met him, he was very eager to complete it. Ask him to get it done. I think he
We'll
can
do
get
it. We'll do it.
Please. Shall we fix a date on
Same date.
28? You, Mr.
28th of-
Bigogoi?
Share the
This is toilet. Yes, toilet we have. Other matters we'll look into, but first toilet is toilet. We can't do anything. You have to.
Well, this 28th of which month? 28th of?
28 August 28th.
Will be sometime in September if you, as far
September
as we are concerned.
For
Because
August, you give us a tentative date
projection.
when it is going to finish. You get your.
At least give it in first week of September if it's not inconvenient for this board.
I know you can get it done. You can persuade your bureaucracy how it is to be done and it can be done. There's no worry with that. Heard Mr. K. N. Balagopal, the learned Advocate General, Nagaland, Mr. Mr. P. Gugoi, the learned Additional Advocate General, Assam, Mr. D. Nath, the learned. You are also an Additional Advocate General? No. Learned Senior Government Advocate, Assam, Mr. A. Chandran, the Senior Government Advocate, so-and-so, Mr. So-and-so, appearing on behalf of State of Nagaland, Mr. R.K. Dev Chaudhary, so-and-so, Mr. H.K. Das, Miss R.S. Chaudhary. You have standing counsel of the High Court, or you have?
I'm the amicus curiae.
You are amicus, no?
So far related.
Okay.
Okay. Issue has started on her.
So, here, amicus curiae, the learned amicus, H.K. Das, the learned standing counsel of the Guwahati High Court. So, from the materials, as it is seen that 30 sites have been earmarked pursuant to orders passed by this court for construction or repairing of toilets. And of which though earmarked for construction of the repairing of toilets. It is fair to see that this court, that the Guwahati High Court on the administrative side have also approved the construction of the repairing of the toilets. And however, it is only in what? 9 earmarked sites, there had been an administrative approval. This court has also we have also taken note of that the amount which is required for the purpose of construction of repairing of the toilets as per as estimated by the PWD, comes to rupees 723.99 lakhs. And only an amount of rupees 3.32 crores have been allotted for construction of the upgradation of toilet for the financial year 2025-26. We have heard the learned counsels appearing on behalf of the parties, learned counsels in that regard. We have also taken note of that the toilets, that the reconstruction and the repairing of the toilets are basic amenities. And providing these basic amenities to the litigants, as well as those in connection with the dispensation of justice is a constitutional duty on the part of the state. Taking into account the above, this court fixes this matter again on taking into account. We express our opinion. We express our observations. We observe that the state of Assam may do the needful so that the necessary approvals are issued at the earliest, so that issued at the earliest, in order to so that the construction oblique repair of the toilets which have been earmarked can be done at the earliest. Insofar as the state of Nagaland is concerned, we have taken note of an affidavit filed by the state of Nagaland dated 1/8/2025, wherein there is a mention that an amount of rupees 80 crores have been sanctioned by the government of Nagaland for the purpose of construction of the new High Court building. We have also heard, the learned Advocate General Nagaland on the aspect as regards when the said High Court building can be completed, taking into account that almost 2 decades have passed from the time the foundation stone was laid. The learned Advocate General submitted that he would talk to the officials and submit before this court a tentative date so that the completion as to when the building, new High Court building of the new High Court building, Kohima, can be completed and handed over. First, list this matter again on 20/08/2025.
So far as Arunachal is concerned, the new building was the issue on the last occasion. We are having the building below. So there is nothing to be done here.
But there are some issues you people talk.
Eviction,
we'll take it some other day.
Because there are issues regarding handing over land
For a new
in
judge,
Shivsagar, in other district, completion of quarters.
Yes. Those
Construction
issues are
of
there.
building.
Yes.
So we'll
Yes. Those issues, my lord, since today is, my lord, confined.
We
confining-
take it up on some day. First, we get the toilets done.
Fine, man. Fine.
Mr. Bigover, this is a very serious thing, huh?
Yes, yes.
Kindly
I will
convey to
convey.
the finance
Yes,
that
yes.
we require this toilet, whatever sanction.
Not-
And the PWD, you are appearing also, no? So when can it be started?
My lord, the
The
date
other buildings,
is 20th or
also identified, this will take some time. It can go on, but not toilets.
my lord, only at the
Get
cost
the
of interruption.
judgment.
Yes, yes.
That I just wanted to know whether the date is 20th or 28th. my
20.
lord. My lord, we have Assam-Nagaland border dispute, my lord, at that time. I was just informed. Any other date convenient to court. If it's first week of September, that would be perfectly, first or second week of September. I would be grateful.
We'll take the Mizoram to Bishop Deduction, Bishop project.
Mr. Advocate General, we will take care of that.
Very, I'm grateful.
28th, we will take care of it.
I'm very
You ask him to, your additional Advocate General to make a submission, we'll take care of it.
Hmm.
We'll
I
fix
was
it.
present when the foundation stone was laid 20 years back. When the foundation stone was laid, the then Chief Justice, Honorable K.G. Balakrishnan was present. And many of our judges came with a lot of fanfare. And many of the judges who participated were later elevated to the Supreme Court also from our High Court. So it was a great celebration. I think we should bring back that gaiety now, and I think it should be done in a very fine manner. I'm grateful that I'm being excused for 20th. I will give the instructions.
We will fix another day, but
Please.
in the meantime, you.
They will be present. They will be
Good
present.
work.
Yes. I will. I'm a best.